May I
Yes.
please, Lord?
Hmm.
My lord, I beg to pray for listing, my lord, on Friday, my lord, for admission, my lord.
Admission
My
matters.
lord.
চাই ল'ব কিমানটা আছে
Obliged.
নহ'লে নেক্সট সপ্তাহ দিম
I'm paying for listing of this matter on this Friday
He'll list it.
for order slots.
Any matter, listing matters, give it to him. অলপ চাই কেনে ভগাই দিব
Very clear, Lord. Sir, documents on item number 15, Lord, sir. Upon instruction, Lord, I like to withdraw this petition, Lord, sir, with liberty. Item 15, that amalgamation matter. I like to withdraw upon instruction, Lord, with liberty, Lord.
Why?
Because
Why liberty?
sometimes, Lord, sir, there is some with liberty. Lord.
Just wait, let the matter be called up.
Obliged.
I beg
Yes.
to maintain item number 25, Lordship. 25. I want to withdraw the main petition, Lordship.
Huh?
I want to withdraw the main petition, Lordship.
Rightly so. Wait, let the matter be called up.
May I please, Lord?
I can't take up.
I have instruction to withdraw the item number 4.
Item number?
4. Party,
Why?
party is not interested.
On the prayer made by Mr. D. Chaudhary, Learned Counsel for the petitioner who submits that he is under instructions from the petitioner not to press this matter anymore. Accordingly, the writ petition stands dismissed on withdrawal. Mr. J. Handick, Learned Standing Counsel, Revenue Department is present.
Obliged.
May it please, my lord. Item number 44, perhaps lordship may not.
I'll not take up, that's what. I thought he is coming to mention for item number 44. Item number 44, list before any other bench without me.
Obliged.
May I please, your lordship? Lordship, I beg to mention for listing, lordship. Matter regarding finance.
Motion,
Yes, lordship.
motion item. What is the urgency?
Contempt cases, lordship.
Contempt cases, how many?
One, lordship.
One time give it. লগাই দিব এটা।
May I-
বুধবার মানে লগাই দিব।
May I please, I beg to mention item 38, Lord, sir. In this case, Mr. Senior Counsel, Mr. Chinmoy Chaudhary appeared. He is not
Oh, sorry,
well.
not keeping well.
So
You're for the making a mention on behalf of the
Yeah.
petitioner.
the petition.
On a prayer made on behalf of Mr. C. Chaudhary, Learned Senior Counsel, who is stated to be indisposed, list this matter again after 2 weeks on a date to.
See, so
3 weeks,
4 is Lord, sir.
4 weeks on a date to.
My lord, a date will be after 4 weeks.
Obliged.
Yes, Mr. Thakur, anything more?
Fine. Yeah.
We'll pass orders. We'll see how best we can do for you. Dispose the file. We'll have it by weekend or by Monday latest. Order.
May I please, Lordship.
Mr. Roy, have you got the records?
The Lordship has closed the order on Thursday.
Hmm.
Friday
No, I
was the
understand.
election
You can
day,
have-
Saturday was a holiday, Sunday.
No problem. You can, when do you want it? I want the records, but otherwise we can't proceed.
Okay, but my lord, will kindly, I'll just point out one thing before
Hmm.
that. Lordship, he has filed a rejoinder on 31/1/2018, from which he said that he submitted application on 31/2007. That is what your lordship wanted. But before that, he has filed another rejoinder prior to that.
I know, I've seen it. I've seen it.
And there the plea is that he
It's
is
totally
suffering-
contradictory.
Totally contradictory.
I know that, but get that, because neither you nor he has brought that on record.
You know,
Only
they have
thing,
sent me a mail.
no problem. You take your time. Mr. Roy, the only thing that is troubling this court is there is a categorical statement made by him that he had disclosed the fact that he was having mental ailment to you. And you have made a statement in your rejoin in your affidavit that till the date he was removed or he was held to have resigned, the company never knew that he was suffering from mental illness.
In fact, the company wrote him a letter. Please come with the records because we don't have.
No, only thing that 2 times rather 3 times, 3 dates were fixed for medical examination. But he did not turn up.
He did not come.
So I just want to know
That's-
whether that
I
medical
understand.
examination was
fact-
on account of
My lord,
mental illness.
no, my lord, in fact, what happened, the legal man who is in charge, my lord, legal section, he himself went. He searched the records on the evening that day. He said since he was not in service of 2009 and he filed the retribution 2013 after 5 years. So readily on that place, current employees.
You get it. We understand. We understand the problem because he came up too late in the matter.
Yeah, yes, Lord.
You get that? Only thing we want to satisfy ourselves is that before that, your statement that before that date, which was then I think 2016-10 or something, when he was held to have resigned from his services, you did not know or he did not communicate that he was suffering from mental illness.
That's it.
The only communication, say a month or 2 before that was that he is suffering from COPD and heart ailments, for which he
That is
wanted a voluntary retirement.
That is there, Malavitas.
That much only I want, because those documents have not been made a part of these records.
A week's time, my lord.
Okay.
Lordship,
Let's this matter again on 30th,
Lord.
30th, on the prayer of Mr. P.K. Roy, Learned.
Lordship, I have here is a report from the ONGC I have received, medical report. That's where he's been admitted by this ONGC. I want to show that document. That document, maybe original document is in there. Let me produce also that document.
Why were these not brought on record in the writ petition or in your rejoinder? You're bringing it in part.
Lordship, what is happened when the phase of the schizophrenia is completely different, but it is probably in the record. Where there is a mental illness is not possible in their hospital, they have been referred to Dibrugarh. My humble submission report is your court. We have received the original format is there. Let the record also take with these documents.
No, let them produce whatever they have.
Produce the documents.
I'll do that. my
This is dated
lord.
22/9. What is the date?
2006, Your Lordship, but if you see the report, Your Lordship, the medical documents, that time even he was in service. We have received some documents. My humble submission, let them produce the documents along with those documents.
On the prayer made on
The
behalf
complete
by
denied.
Mr. S.K. Chakraborty, Learned Counsel, assisting Mr. P.K. Roy, Learned Senior Counsel, appearing for the ONGC Limited. Matter stands adjourned to 30/4/2024, enabling the Learned Counsel to procure the relevant records from the company, from the respondent, number 1 corporation.
Fixing on 30th.
30th. Or you want a date? I can, there's no issue.
30th.
30th, fine. We'll see on 30th.
My lord.
And you do one thing, Mr. Gogoi, give that a copy to Mr. Roy also. Mr. Chakraborty, just give a copy so that they can.
They
factor
come
in
up with
that.
that.
My lord, my senior is out of station today. So the matter may be fixed after 7 May.
Where is Mr. RKD Chaudhary? You are appearing for Mr. Rabha.
Yeah.
No problem. We want Mr. RKD Chaudhary. Get hold of him. Deputy SGY. List this matter along. It will item number 58. Mr. Das, we'll have it along with item number 58 because there is one lady against whom one petitioner who has come up against whom in pursuance to the orders, a recovery was done. So they have now challenged that. So we'll have this along with item number 58. 58 all over. Time being good. Yes, madam.
May it please your lordship. Case list to compassionate appointment lordships.
Date of death 2008.
Father died 2009,
Eight.
immediately 2000.
Application 2009.
Date of the father is 1/7/2009.
No, 27/12/2008.
2008.
Nothing.
No, my lord, what happened in this case, my lord?
Hmm,
His name is shown in the district level committee in the year 2012.
I know.
But there is, they have not.
Show
been-
me, I forget all this. Show me how you were pursuing the matter. 2008-9, after you filed the application, you were in a very
No,
bad
my lord,
situation.
in Fazlun Nisa, my lord, there is a.
Fazlun
that-
Nisa,
they
the
have
Supreme Court, Fazlun Nisa gone now. Debabrata Tibari.
And continuation also there because I have filed affidavit, we have filed several repetition, my lord.
What prevented you from approaching this court? Because you are in a precarious condition. You can't sustain yourself. What prevented you from coming this before this court? And all the applications sometime in now after around how many 15-16 years should we come in? You filed this application only on 11/12/2023.
No, my lord, lordship kindly peruse the affidavit, my lord. I have filed
Additional affidavit.
additional affidavit.
You have brought on record
Yes,
certain,
my lord.
and that also from 2014 onwards.
And lordships 14, 16.
Huh.
And after obtaining the, my lord, we have filed by our way of RTI, my lord, we have obtained all this, we have come to know that our case has been not rejected, my lord, it is pending.
Whatever they do,
It
they'll
is
do.
pending, my lord, it has
Whatever
not
they do,
rejected.
they will do, madam, but we are not coming in after 15 years. 16 years for
But
compassionate
since the
appointment.
continuation is there, lordship can leave, can.
Immediacy.
I want
Immediacy.
only to send the matter to the DLC, nothing more
We
than
will
that.
not. Show me a law to that extent.
Then I
that
need
after
some more
15
time, my lord.
No need, no time. Nothing can be developed. We had given time here
No, I have to go through the.
on
Supreme
from, we
Court
are
order, my
considering
lord.
this matter, madam, from
My lord, I.
December. December onwards, we are considering this matter. We have been accommodating you.
Yes, yes, yes.
December,
Lordship, let your
January,
lordship pleases them. I don't want to go.
Christmas.
Only my name may be.
I have been very
No, I
consistent in,
haven't gone through the Supreme Court order, of course. my
I have
lord.
told her also on the last occasion.
But kindly my name may be.
Because, yes,
Yes.
Ms. Pidas, will record.
Highly obliged. DPO. নাপাওঁ যদি আৰু কাম নাই। My lord, in this case, affidavit is ready, my lord. Madam may take up next week.
Item number?
They're supposed to file affidavit, my lord.
No, it has already sent for vetting, my lord.
They have not filed, my lord. I am praying for my lord interim protection.
Okay, that appointment matter.
Hmm.
On the prayer of Ms. S. Sutiel and a counsel for the petitioner, list this matter again on 1/5/2024. So enabling, enabling the state, the respondents in the elementary education department to bring on record stand by way of filing an affidavit. Also, it is noted, it is to be noted that in the event no affidavit is filed by the next date fixed, the matter would be proceeded with basing on the materials already available of record.
Non-compliance of order 31/23, lordship.
How is this petition, contempt petition maintainable?
Lordship, there is a direction to comply the order. within
30 days.
30 days.
So 30 days was over
Then lordship,
sometime in,
that is.
30 days from the date of the order,
23,
right?
Page 59. Page 59, pursuant to the
Okay.
order. The meeting of SLC was held on page 59, lordship.
59.
Yes, 23/3. But there is a observation,
Hmm.
First, second, third pair, lordship, before the box.
Hmm.
In the light of the aforesaid judgment of the Honorable Guwahati High Court, as the Chief Secretary, Assam request to concern the member secretaries to place High Court cases where the court has passed orders referring to the above judgment. My serial number 8, lordship. Next page, lordship. And next page, after the box, Lordship, as the concerned department could not place the necessary records of the application to determine the merit of the cases in terms so and so dated so and so, following direction issued by the SLC. Lordship, there is nothing happened, Lordship. They are sleeping over the matter. It is why, Lordship, now I have filed this case.
Okay. Issue notice. Heard Mr. S. Amit Lanak, counsel for the petitioner, issue notice, returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents by way of registered post with 80 steps within 2 days.
Madam.
Page 8 is the order, madam.
Hmm?
Page 8, madam. There was a direction to consider his case for provincialization, madam. What happened, my lord, instead of, my lord, his date of appointment joining was shown as 2007, it was shown as 17. And because of that mistake, he was left out,
Mr. Datta,
my lord.
come to the order
Yes, madam.
at page 9.
Yes, madam.
So it was given to the director and the
Yes.
director was to take steps in the matter. Now you have annexed that order of the director
Yes, madam. That is
at
there.
page 20. What
Yes.
contempt? There is no contempt.
My lord,
The consequential actions are not covered by the order.
that is
If
there.
there is something, you will have to come up with a fresh application. The detailed order has been passed and your case has been placed before the.
That I understand, but then this is basically non-company, this is.
There
doesn't-
cannot be a willful and deliberate
I
violation.
understand.
Without that, how can I exercise?
I was just telling my friend the same thing, well, but then the difficulties when these are complaint.
You can always come back because
Then I have to file a separate writ for that, my lord.
wait for that because now you have a right that has accrued. to
Yes, that is there, my lord. That is there.
Heard Mr. M. Dr. Leonard, counsel for the petitioner. The present contempt petition has been filed alleging violation of the directions as passed by this court by order dated 24/3/2023 in WPC number 6505/2022. On perusal of the directions as contained in the said order, it is seen that the Director of Elementary Education was directed to take a call in the matter with regard to the grievances as highlighted by the petitioner in the said proceedings. Also, it is seen that the grievances of the petitioner was duly considered by the SLC and the director, while a communication dated 14/12/2023 has placed the case of the petitioner before the government in the Department of School Education, praying for sanction of a post of tutor, bracketed science, in the name of the petitioner herein for provincialization of his services. In view of the said steps as taken by the Director of Elementary Education, Assam, this court is of the considered view that there is no willful and or deliberate violation of the directions passed by this court by the order dated 24/3/2023, and accordingly, the present contempt petition is held to be not maintainable. Full stop. The contempt petition accordingly stands closed.
I give the liberty with your approach.
It's always there. Because that we are not, that order this court passed has been complied with. Now, if
I
no
understand.
further action is taken, you please
Sure,
proceed.
that's what.
Very clear, Lordship. Kindly bear the last order.
After some time. They are getting it today. They'll get it today,
After some time.
after some time. We have decided that we will direct for a investigation by the CID and we are imposing a cost. And we'll fix the matter after 4 weeks, enabling them to bring on record their report. You'll have the order by tomorrow evening or Wednesday morning.
Fine.
I'll to move the. Dispose now, it. Dispose.
Pending, my lord.
It will be pending.
Yeah, please, Lordship. In this case, instruction was not followed with. Whether his voluntary retirement application was accepted or not.
Forget it. It was not accepted. Now satisfy me.
Lordship.
Satisfy this court.
Lordship, in this case, Lordship.
No. We will not proceed. You come to the document you have annexed at page 22,
22.
by which your wife was appointed. Right?
Yes, Lordship.
And therein, what is the word used?
Yes, my lord. We have
Come to the vernacular. That will be more relevant.
But Lordship, the order at page.
Page 23. Read the page, order 23. Page 23 order.
Lordship. Yes, that is there, Lordship, that Pranab Bora
Not
earlier
this.
hereby regularized,
for the
which seems
No, read the vernacular one. Page 23.
pursuant to the approval given by the select.
No. Read the
23, Lordship.
23. Zorat Mahkuma.
যোৰহাট মহকুমাৰ কানুপুখুৰী মধ্য ইংৰাজী বিদ্যালয়ৰ সহকাৰী শিক্ষক প্ৰদীপ চুতীয়া ইস্তফা দিয়া খালী পদ
What is the word used? Istifa.
ইস্তফা Lordship.
Istifa means what? Resignation.
Resignation, Lordship.
Resignation means forfeiture of all earlier things. And this is an order issued while appointing your wife.
Lordship, it is there, Lordship, but
No relief is required to be granted here.
Lordship, the court,
This is not this case.
my lord, item number 14 regarding item number 30.
Tell me what to do now. You are not entitled. And the order rightly has rejected your case.
the order at page 30, Lordship.
36 is the relevant one. Rightly. Resignation, you got your wife in, that is enough. That's more than enough relief you have got.
So in this case, matter may kindly be adjourned, my senior will.
No. Nothing is here. We are not proceeding with this matters. And you come before this court, Mr. Bhattakur is here. Yes, Mr. Bhattakur.
Lordship,
Istifa.
Lordship, let them file an affidavit.
No need. You have brought this document on record.
Which your Lordship?
Page 23. And you have not clarified that that is wrong. Appointing your wife in your place. See the second line. Shri Pradeep Sotia
Yes, your
istifa here.
Lordship will kindly see then, your Lordship. There are other documents, your Lordship.
The
That's,
other documents are subsequent documents, Mr.
Lordship,
Bhattakur.
but that's those documents, your Lordship are.
And tell me, how long have you been in service?
Lordship,
How long have you been in service after your service was provincialized?
70 to 90.
13 years?
no, your Lord, 70 to 90. Your
No.
Lordship.
You were provincialized with deficit grants in aid from 1777.
Lordship,
Oh, sorry, 1378.
your Lordship will kindly come to page 19.
No.
Your Lordship may take this matter, your Lordship, day after tomorrow, your Lordship. I will satisfy your Lordship. Since your Lordship has directed them to take
Forget it.
instruction, your Lordship,
They don't get it. We will proceed with what is there on record.
then your Lordship, day after tomorrow.
Mr. Bhattakur, 78, you were provincialized.
Lordship,
So your period will bring in from 78.
but your Lordship.
One second. Satisfy me on this. 13 years service. Show me the law that
Lordship,
you can proceed on voluntary retirement without an approval.
without your Lordship,
Approval. We'll deem that
Lord.
this is a,
Lordship,
show me that law. And page 23 istifa.
Lordship, those your Lordship, I will.
And you can't deny that document, page 23,
Lordship, that's why I
because
have
it
brought
is
you.
your wife's appointment.
Lordship, maybe your Lordship, that's my wife is has an independent, your
No,
Lordship.
that document is with you.
Yes.
And you have not made any statement in the writ petition saying that word istifa is wrong.
No, I have said that I have taken voluntary retirement, your Lordship.
And your application is also not there.
No,
Your
application-
acceptance is not there.
It is their duty to
It's
produce.
only a projection made as rightly held in the impugned order
Lordship,
by you and the district authorities.
Lordship.
Wednesday.
I will satisfy you.
On the prayer of Mr. S. Bhattakur, list this matter again on 24, 4/20.
Lordship. Oblige, your Lordship.
Last order, my lord. They are directed to produce the
Yeah, this is the instruction.
My lord.
Huh? কাগজ দিছিল না এটা instruction.
instruction, you know.
Real money. Okay.
Volume Malayali.
Okay. Make your submissions. What is your submission?
The petitioner, my lord, is the elected president of Ghorial Mari LP School, my lord.
Hmm.
His committee has been constituted, my lord, on 22/12/2022, my lord.
Page?
Page, my lord, 36, my lord. One of copy, my lord.
Hmm.
The
Nazma
approval-
Khatun.
Nazma Khatun, my lord.
Hmm.
The approval was 22/12/2022. my lord.
Hmm.
She has been made president, my lord, for a period of 3 years, my lord.
Hmm.
As per the
Hmm. Hmm.
notification, my lord.
Hmm.
But here in this case, my lord, by the impugned order dated 30/8/2023, my lord, the the district preliminary education officer Porpeta, my lord, by which the deputy inspector of schools Porpeta and Bozali, as well as the preliminary education officers,
Hmm.
all are directed to instruct all govt provincialized elementary schools, my lord, under their jurisdiction to initiate the process of reconstitution of school management committee, my lord,
Hmm.
before completing the tenure of the existing management committee.
Hmm.
In total violation of the.
You are continuing in terms of the orders of this court?
Yes, my lord.
Okay, whatever. They want to reconstitute it. What right do you have?
Yes, ma'am.
What right do you have?
But she has been.
Fine, that was not in terms of the, seems that the government had taken a decision that they
Yes.
are going to reconstitute not only in your school, but all schools, irrespective of.
Kindly see the notification, my lord.
Huh.
As per the notification dated 3/8/2023, my lord,
Hmm.
the new committee should be constituted
Hmm.
1 month before the expiry of the term of the outgoing committee, my lord. Kindly see that notification, my lord.
And you say that this is not applicable.
Yes, my lord.
Yes, madam.
As per our instruction, my lord, the local people and the guardians of the say school were unable to select the president, and later on.
You do one
the
thing.
Of the honorable court's order.
You do one thing. If this is in terms of, only on terms of 38/2023, page 46.
Yes.
Or it is for some other reason.
Yes.
Okay. On the next date, fix Ms. N. Fukan Lanet, Standing Council Elementary Education Department shall receive instructions from the District Elementary Education Officer Barpeta as to whether the reconstitution of the petitioner, the reconstitution of the school managing committee with the petitioner as its president was so necessitated only on account of the prescriptions as made in the communication dated 38/2023 bracketed Annexure E to the writ petition, and or there exists some other reason as to why the authorities desire to have the said committee reconstituted. Full stop. List this matter again on 1/5/2025. 2024. The interim order passed earlier to continue till. You keep this back.
Fine.
Ekdam correct. Yes, Mr. Decca. Item number 15 is yours.
What's it?
You don't want to press it.
Yes, Lord.
You have already an order.
No, true, Lordship, but
Then-
that's why there's already.
You are not disturbed. The communication, the order is continuing.
But
And
yes.
if somebody is violating this, come with a contempt
So
application.
authority has already admitted that yes, in violation of this order has been issued. Even thereafter, we approach this because protection is given, appeal filed, yet to be disposed of.
Mr.
But the
Decca,
difficulty is
Mr.
that
Decca, if the district authorities are doing something which they ought not to have, File a proper application.
Already
before-
students are compelled to join in the base course.
You file a.
Yes, Lord. They
file a-
we
file a-
have
file a-
filed, we file a representative. That is why actually debate this.
Mr. Also, the Mr. A. Dekalan, counsel for the petitioner. Upon arguing the matter for some time by referring to the directions as contained in the order dated 8/12/2022 passed by this court in WPC number 7884/2022 submits that the interim directions as passed therein continues to hold the field and the appeal as filed by the petitioner in the matter is yet to be disposed of by the respondent by the appellate authority. Full stop. In view of the said position, no further orders are called for in the present proceedings and accordingly, the present proceeding stands closed. I'll only say that much.
Please, your lordship,
Yes, madam.
appointed as a president of this, my lord, A.K. Azad High School and as per annexure 2, my lord. Thereafter, my lord, she was removed, my lord, without any valid ground, my lord.
Now, madam, there is a complaint against you. You have brought it on
Yes, my
record.
lord.
Page 39.
In the system,
Page 39. You have brought it on record.
my lord.
Come to that third paragraph.
My lord. May I read, my lord?
Hmm.
That the SMDC president threats the house by saying that she is a political leader and she is a contested AP members of Puraharia GP. She can do anything,
So
whatever.
where is your statement in the writ petition denying this, that you were not contested a panchayat election?
My lord. This
You have
actually-
brought this. This is the allegation that main allegation is you have contested, and if you are a political person, you are not entitled to be a president.
My lord, she is appointed as a president, my lord. There is, my lord, some local peoples.
No,
are,
no,
my
no.
lord,
This
signature-
statement that is there, have you denied somewhere?
I have filed my lord, additional affidavit, my lord.
No. Will not permit it. And what right has been violated? Show me that.
My lord, she.
Some right has to be violated.
My
You are
lord,
not there, somebody else will be there. What right of, what,
and-
is it a regular appointment? So nomination,
My lord,
right? Where is the question of
my lord,
pre-decisional hearing here?
my lord, some local peoples are signature, my lord, that is no.
Whoever it is, whoever it is,
Yeah.
in this two view of the matter, why should this court entertain this
My lord,
application?
My humble prayer before your lordship, my lord, at least instruction may be given, my lord.
No.
That this is statement.
No instruction required. Your document you have not dealt with. Why should we proceed any further? This has been brought on record by you. I have tried to see whether there is anything. There is nothing. Satisfy me. 2 o'clock. You read.
My lord.
May I please stop? Lordship, impugn order is page 71, Lordship. Petitioners appeal for provincialization under the new act, Lordship, rejected on the ground of 2H of the Provincialization Act 2017, Lordship. And the provision 2H is non-recommendation by the District Disciplinary Committee. So may I pray that, Lordship, limited prayer, direct the respondent authority to place the case of the petitioner before the District Disciplinary Committee. Earlier under 2011 Act, he was eligible, but he has been left out. In spite of.
Last occasion, why did you withdraw the application for filing an appeal? Because there was nothing here to file an appeal. There was no decision of the DLC or the SLC.
No, no
Then
decision.
you invited this yourself. And that letter, page 73, shows that in 2017, only 8 candidates were there, students were there. Right?
But
Where is your
at
right?
the time of filing this appeal?
No.
23.
No, it will be as per the act. And as decided by this court, the cutoff date year would be 2017. And 2017, it seems that you have only
17 to
8.
lordship.
So
But at the time of filing this appeal lordship, he has 10 students lordship.
do one thing. We will not permit this because of this condition. You have anything to say on this? This has been brought on record by you yourself.
Lordship.
And there are other
I cannot deny,
documents
but
also.
That is the fact also.
Then, so in terms of that, you require 10. Right? How can we now come in your help in terms of that provisions of the act? Just satisfy this court on that.
Lordship.
I'll have to dismiss it. Your appeal is in page.
Appeal has not been annexed, but in the impugn order, lordship, it has been.
That appeal is not on record,
No, on the-
right?
but it has been filed on 10th of May 2023.
23. There is another one of 9/1/2017, but the appeal that was filed on 10/5 is not on record. Dismiss. I'll do it.
So matter may be taken after some time.
Huh?
After some time.
Mr. Chaudhary, have you got the instructions? Yes, Mr. Roy.
But in this case, my lord, petitioner participated in a selection process, my lord. And accordingly, he
Have you got the reasons?
Yes, my lord.
You have got the reasons.
Yes, my lord. That is
They have handed over to you.
Yes.
Okay.
Page 57.
Heard Mr. S.K. Roy, learned counsel for the petitioner. Also heard Mr. U. Sharma, learned counsel, standing counsel, secondary education department. Issue notice, returnable 4 months, 4 weeks. Mr. D. Dury, learned junior government advocate, accepts notice on behalf of respondent number 1 and 2. Mr. Sharma, you are for 3. 3. Mr. C. Sharma, learned standing counsel, Department of Social Justice and Empowerment, accepts notice on behalf of respondent number 3. Who is for the health? Mr. Gogoi is here. Mr. Gogoi is here. D. Gogoi or anybody. Just give that name, whoever, one name.
You.
Huh?
You.
Mr. Nayak is here.
You.
D.
D. Upamanyu, learned standing counsel, Health and Family Welfare Department, accepts notice on behalf of respondent number 4, 5, 4. Who is for 5? 5 will be you only. Ms. You, Sharma? You, 5. You, B. Dury, 1, 2, and 5. Huh? and Mr. U Sharma for respondents number, accepts notice for respondent number 6 and 7. और you लिखा था ना, उसका नाम देना, 4 and 8. No formal notice is to be issued. However, petitioner to serve requisite extra copies of the petition on the learned standing council. Also, list this matter again after 4 weeks on a date to be fixed by the registrar. We'll see.
My lord, the select list will be expired on 8/5, my lord. So the validity of the selection.
You have already filed a writ petition. Validity stands extended. Find out that judgments.
My lord, that judgment says that unless there is a specific order extending the validity, in another case, my.
It is the petitioner has raised an apprehension that the select list in question would lose its validity
Select list
on,
dated, my lord,
on
9/5.
on 9/5/2024. Also, this court having entertained the writ
Expired on
petition today,
8/5/2020.
also, the said aspect of the matter would also be duly considered at the time of final hearing of the present writ petition. At the time of disposal of the present petition.
My lord, other my lord, the advertisement has been issued, my lord. Unless, my lord, one post may be kept vacant, my lord.
No, you participate. We'll give you liberty. We'll give you liberty, you participate without prejudice to your claims here. You have participated,
No.
then forget it.
Lordship, I am appearing for respondent number 5.
Mr. B. Chaudhary. Huh? Appears for the respondent number 5. थोड़ा ठीक कर लेना. Mr. D. Upamanu.
4, 6 and 7 I am appearing.
For an 8, उसको कर दो. Mr. D. को कोई कर दो. Okay, Mr. Gogoi? 4 and 8.
7 and 8 I am appearing.
4,
6, 7 and 8.
6 is not. 7 and 8. 4, 7 and 8.
Oh, yes, sorry, bhai. 7 and 8. Four,
नया
seven,
से दे रहा है रुको. Mr. B. Dury for respondent number 1 and 2. Mr. C. Sharma for respondent number 3. Mr. B. Gogoi for respondent number 4, 7 and 8. Mr. B. Chaudhary for respondent number 5. Mr. U. Sharma for respondent number 6. Heard Mr. B. Purkaisto, Lanet Counsel for the petitioner. Also heard Mr. U. Sharma, Lanet Counsel, appearing for the secondary education department. Issue notice, returnable 6 weeks. 4 weeks. Mr. Sharma accepts notice on behalf of the respondent number 1, 2, and 3. No formal notice is issued. However, extra copies of the requisite extra copies of the petition be furnished for the Lanet Standing Council. Petitioner to take steps for notice, issuance of notice upon respondent number 4 by registered post with AD. Also, pending consideration of the issues as arising in the present proceedings and also on perusal of the directions as passed by this court by order dated 18/12/2023 in WPC number 5419/2023. The impugned order dated 7/4/2024 passed by the
DSC Assam.
dear Director of Secondary Education Assam shall remain stayed. Can't help it. If they don't understand, they don't understand.
They
We can't-
sometimes, they have filed the
We can't
affidavit, my
help it.
lord,
We can't help it.
stating that they
That
are,
affidavit is again on 2 points.
yes.
We exactly don't know from that affidavit, apologies asked for the first point or the second point.
Oh.
That's why I did not proceed further. If it was there, that it was clear that it was for the first point,
Yes.
I would have drawn up contempt proceedings today. That's it. You are protected.
My lord, for non-consideration of promotion, my lord, I am hearing challenges the impugned minutes of the meeting, my lord. Relevant page at page 73, my lord. In spite of clear
No.
vacancies, my lord.
This matter has been wrongly listed before this meant. The matter pertains to civil bench 3, registry to examine the same and list accordingly. The civil bench 3 matter.
Sorry.
May I please, your lordship? My lord, impugned order at page 55.
Appropriate bench should be. Itu order did.
Page 55, my lord.
Hmm?
Page 55, impugned order. From fourth paragraph, kindly see, page 55. Annexure 11.
Same order. Same order.
No.
Lordship, there is already an order passed by the honorable court at page 69, Lordship.
Your impugned order is 23, 2024.
Impugned order is at Lordship, yes.
Heard Mr. S.K. Das. Lanak.
Lordship, I have obtained prior permission, Lordship, from the inspector of schools.
Now, interim order, this has to be stayed.
Yes, Lord.
We will stay there. We will consider subsequently. Heard Mr. S.K. Das, Learned Counsel for the petitioner. Also heard Mr. U. Sharma, Learned Standing Counsel, Secondary Education Department. So issue notice, returnable 4 weeks. Mr. U. Sharma accepts notice on behalf of the respondent number 1, 2, 3, and 4. Notice, notice upon respondent number 5, B. No formal notice is to be issued. However, requisite extra copies of the petition be furnished to Learned Standing Counsel. Notice upon respondent number 5 be issued to Mr. R. Mojumdar, Learned Standing Counsel, Dibrugarh University. Full stop. Considering the submissions as advanced in the matter by the petitioner and also the orders passed by this court in WPC number 6938/2023, this court is prima facie satisfied that the impugned order dated 23/2024 has been so passed in clear violation of the directions as contained in the said order dated Five 12/2023 in WBC number 6938/2023, as well as the similar orders passed by this court on the issue as involved in the proceeding. Accordingly, till the next returnable date, the order dated 23/2024 passed by the Director, Secondary Education Assam shall remain stayed.
All right.
Mr. Sharma, there are series of orders passed by this court. And still, if you are not able to make your officers understand, tell us. We know how to make them understand. You get my point?
Yes, yes.
Next time, if I find a similar order like this, we are proceeding to draw contempt against the officer. Either she has not understood or deliberately not trying to understand. Yes, Mr. Chaudhary.
My lord, our basic case is, my lord, when we approached the, my lord, fee regulatory committee, the data was wrong.
The first
that-
data was wrong.
Wrong.
And
My lord, our
unfortunately,
case is-
they have proceeded with that data till date.
Yes,
Now, Mr. Chaudhary, one query.
yes.
Now, these two are bodies.
Hmm.
Now, will they be able to come and justify their stand? If we issue a notice to them, who will now appear on their behalf? This is something troubling me.
Okay. How to go?
Proceeding officers.
Not a party convention. No, my lord, they are represented.
They are represented.
Yes.
So it's not like a court, but they can give the records because we'll have to have the materials.
Basically, I think the administrative department, that is Government of Assam Education Department will
We'll have
be-
to. So
It's something like, my lord, Central Administrative Tribunal passing an order.
order, that's what I'm.
At end of the day, it is the Government of
Government
Assam
who will have
Personnel
to defend.
Department or.
So should we issue a notice to the
My
respondent?
only prayer is, Lordship will issue a notice at this stage and no.
We will say
coercive
no
measure
coercive action.
Person to that two impugned order.
We will say no coercive action against you.
Yes,
Pursuant to that 5-1 and
one page 183.
5-1 and 20,
Yes,
27-3.
yes, 5-1 and 27-3.
So we'll issue notice on the 2 and 3 also.
My lord, we'll only pray for remand of the matter, nothing beyond.
I know that, but let us hear them first.
My lord, 5-1, 9-2 and 27-3. There are three orders, 163, 183, 200.
163,
183 and
183.
200. Pages.
But Mr. K. Chaudhary, learned counsel for the learned senior counsel, assisted by Mr. S.P. Sharma, learned counsel appearing for the petitions. He also heard Mr. U. Sharma, learned standing counsel,
For respondent
Department,
number one, my lord.
Department of Secondary Education. Issue notice returnable 4 weeks. Mr. U. Sharma accepts notice on behalf of respondent number 1. No formal notice is to be issued. However, requisite extra copies of the petition be furnished to the learned standing counsel. Petitioner to take steps for service of notice upon respondent number 2 and 3 by way of registered post with AD, also by Dusty, and also by Dusty mode routed through the registry of this court. Also, petitioner to file an affidavit after effecting service upon respondent number 2 and 3 by way of Dusty mode. Also, consider the submissions made by the learned counsel appearing in the matter pertaining to the prayer for interim relief. Upon considering the submissions so made and being prima facie satisfied with the same, this court hereby directs the respondent authorities not to take any coercive action against the petitioner's school in pursuance to the order
Annexure
dated
21, 22 and 23, my lord.
order dated 5/1/2024 passed by the
Fee
fee
revision
revision committee and
Second one, 22 by fee regulatory committee, my lord. 2 and 3, 22 and 23 are by fee regulatory commission.
and the communications dated 9/2/2024 and 27/3/2024 by the pre-regulatory committee till the next returnable date.
Deeply applied.
Please, your lordship, mine is a contempt case, my lord. The violation of the interim order.
Show me willful and deliberate violation.
My lord. your
Madam,
lordship,
there are two parts to that order, right?
Because the, my lord, contempt.
There are two
order
parts to that order.
signed.
There are two parts to that order.
Yes, my lord.
If you come to page 11, para 9, has para 9 been complied with?
Para 9, no, my lord.
Inspector of schools has not been given the charge.
No, my lord.
Sure.
Yes.
Miss S.B. Chaudhary, learned counsel for the petitioner. Also heard. Mr. Sharma is gone. Madam will give you a copy of the order, right? This order was passed on T4/2024. It is our submission that we had required that the post of principal be not be held by the respondent number 5 and the inspector of schools to hold it. She contends that the inspector of schools has not been allowed to hold. The respondent number 5 is continuing. Just have your instruction on that. Right? Mr. U. Sharma, in view of the submissions made by the learned counsel for the petitioner in the matter that the direction as passed by this court requiring the inspector of schools, Barpeta District Circle, Barpeta, to hold the charge of the post of principal during the pendency of the present proceedings and restraining the respondent number 5 to function as such has not been complied with by the respondent authority. So accordingly, Mr. U. Sharma, learned standing counsel, Secondary Education Department is requested to receive instructions in the matter from the Director, Secondary Education, as well as the Inspector of Schools, Barpeta District Circle. So list this matter again. How many days? Week? Monday? 29? Next Monday? 29?
29.
Just that a phone
Yes.
telephonic instruction, that's all.
Yes, yes.
29. 2024. We'll see on 29. But your second part, madam, there can be no contempt. Paragraph 10, there can be no contempt. 9, yes.
In this,
Yes, Mr. Padak,
Lordship, in this
Huh?
matter and
not allowing us to resolve an issue, huh?
Lordship. Lordship, an
Yes.
order of recovery has been passed
Hmm.
in April of 2024.
Now justify
No,
whether you were eligible to that amount.
Lordship, I am eligible.
And
I'll
you
just
are not a group C or a group D employee.
in that, Lordship,
You are not a group C and group D employee.
no, Rafiq Masih, Lordship,
Second paragraph.
yes. And besides that, I'll show I am eligible. Even assuming for the sake of argument that I am not eligible. At this stage, as
No.
per
Odious Zaman to it.
Lordship, I'll show I am eligible, but I'm just,
No, there is a, when the other petitioner came up before this court,
Lordship, there was a specific condition in his appointment order. From the order, it appears that you will only get the scale of pay when you have completed the
I'm
MPhil.
not on that. When the issue was raised before this court, the respondent authorities, because he had referred to certain similar people.
Lordship,
This court, that order, the authority said all those are illegal orders.
Lordship,
We are recovering.
yes,
We are not paying them.
Lord-
But unfortunately, your name is not here.
Lordship,
One Aparna Tamuli was there.
yes,
We find this order was passed in February. In March, this order was passed on 8/2/2017 in his case.
Hmm.
Right?
Hmm.
That we are not paying them.
Hmm.
It is illegal.
Hmm.
We will not pay.
Hmm.
Everything, Commission Secretary. After not even a month, on 27/3/2027, 14 lakhs released. That is what triggered of this matter. Anyway, we'll protect you.
Okay.
Mr.
Yes, my lord.
Yes, Mr. Das.
Let notice be issued, my lord, we will file,
No,
because, my lord, that steps has been taken as per.
you have got your regular pension, no?
I was getting my regular pension.
Now they want to recover.
Yes, I retired in 2016. itself.
16 itself. huh?
Yes, sir.
Where is that impugned order?
The impugned order, your lordship will find at page number 68 and 69.
Heard Mr. KP Pathak, Learned Council, for the petitioner. Also heard Mr. S. Das, Learned Standing Council, Higher Education Department, and also Mr. Aldal. You are paying for 5. That's one number 5. Also.
For the respondent number 7, perhaps my learned friend can take notice, your lordship. I'd implemented him as a performer.
No need. We are not issuing a notice. Also, considering the demands raised in the present proceeding and its relation to the proceedings in pending before this court in WPC number 4151/2017, this present writ petition is directed to be listed along with writ petition number 4151/2017 on 7/5/2024. Full stop. Mr. Das shall receive instructions in the matter and place the same on the next date fixed, that is on 7/5/2024. Till the next returnable date, the only one,
2 orders, your lordship. Annexures SNT 68, 69.
the communications dated 1/4/2024 and 4/4/2024 issued by the Director of Higher Education Assam and the principal DHSK Commerce College, Dibrugarh, respectively, shall remain stayed.
Lordship may kindly observe that any consequential actions may also be remain. Because they have written to the
Shall
treasury.
remain state further, along with any consequential actions that may have been taken and or proposed to be taken in pursuance to the said communications. ऐसा लिखना, हाँ? Communications dated 1/4 and 4/4/2024 issued by the Director of Higher Education Assam and Principal so and so, comma, along with any consequential actions thereon taken and or proposed to be taken shall remain state till the next date fixed. List this matter again on
Lordship,
It's
this
not
order
7
is
fights.
against, Lordship will be contrary to, because your Lordship had earlier passed an order to take remedial measures. What steps they have taken? Now.
Same, Mr. Das. We are only concerned with Madam Aparna Tamuli there in your that earlier matter. Now, this lady retired in 2016. After 4 years, or 16, wait. 16, she retired. He has not argued that, but that's the thing why this order is being brought. Today, it's 8 years.
8 years.
Today, if there has to be a recovery from her, there has to be a proceeding.
Proceeding.
No proceeding prior to 4 years can be taken. So she is in this safe.
Lordship, I am
We
not
have
against-
kept here, we could have allowed this writ petition today itself, but we have kept here just to see the stand of the
Lordship,
government.
I am not against his recovery.
We are not against anybody. We
I am
are
also
done.
seeking for Lordship similar benefit given.
Mr. Das, if she is given this benefit, we have said that they will have to give you that. There will be more petitions. Don't worry. We are just waiting for the others also to join the fray. And then we will proceed. There are another 3 writ petitions which has to come on record. Let those 3 also come. Then we will get hold of Mr. Das. But in her case, admittedly, no steps can be taken beyond 4 years. See that provision of the pension rules.
Deeply obliged.
Please, your lordship.
But it is. So, motion thagi jo ekdam.
Lordship, it will come in the top of the list because item number 5 is in the top of the list.
Let it come. Motion. Whenever it comes, we will take it up to them.
Please, your lordship.
And tell Mr. Pathak to file the other 2 writ petitions also first.
You will be in contact with her.
Yes.
May I please, your lordship? My lord, I am sorry to interfere. My lord. Item number 11.
We are calling it up. 11, ne?
My lord, here, my lord, we have not received any information, my lord, from the government.
Why? 2 o'clock.
My lord,
2 o'clock.
any.
We have given enough time, ma'am. We have given you enough time.
Friday, my
No. 2 o'clock. Just a phone call.
lord, already I have called.
Then, if they can't do it, why are they keep? Just tell them that they are processing it. Fine. That will also do for me.
I have some difficulty, so my lord, tomorrow.
Tomorrow.
Fine.
By sleep, Pothadibu. On the prayer of Miss N. Fukan, list this matter again. Tomorrow. Video.
Like.
You have problem? No problem. But we require that information. 3-4 dates doesn't look nice.
Today is the 5th, my lord.
Deeply obliged.
Today is the
5th day, huh? Yes, Mr. Chaudhary is here. Night.
Item 6.
Mr. Sheikh has not rejoined.
Instruction received.
Receipt, show me.
Criminal cases, your lordship, pending. It was not neither disposed of, your lordship, that's why his representation has not been granted, your lordship.
Is there a power when it is a ad hoc or a pleasure appointment like this to suspend somebody? Do you have that power?
Your lordship,
Either you remove him. Mr. Sheikh was not keeping well, so we are not considering the matter. Today we will take it up on some other day. None appears for the petitioner even on second call. However, for the ends of justice, list this matter again on 26/4/2024. The instructions as placed on record, received by Ms. P. Das and placed on record is kept and furnished to this court is kept on record and marked as X for the purpose of identification. It will be
Deeply
26. Oh, ho. 9-5 করে দিও 9-5 তুমি লিখিছিলা নাকি তো আইটেম নাম্বার 18 and 58 18 and 58 তো আপনি ইয়া করে দিব 8 তারিখে ইলেকশন আছে 9 তারিখ করে দিব এটা করে দিব এটা
Item 18.
Yes, Mr. Hazarika, have you got it?
One merit list was being communicated to me, your lordship, in which your lordship has queried that whether optimum mark is 15. 20 out of 20 was being awarded, your lordship. That is, the document is there, your lordship.
একটু লই লক
Kindly come to page number 7. Page number 7, the PT, page number 8. Number 8. Page number 8, the at serial number 326, Gopal Krishna Sarkar as the petitioner, he was awarded 0 marks.
That is the initial.
Right, second column, your lordship, educational and experience marks. As per page 1. That is 20 marks. And
So thereafter,
extreme
15 marks was given to you.
no marks was given.
No. Initially it was not given. Then you approached this court.
Or then 15 marks were
Was given.
awarded, your lordship. And lordship will find at page 2 of this merit list, your lordship.
Why 2? Come to the first page itself. Second column from the right,
Yes.
20.
Yes, it is 20 out of 20, 15, 15, 15, 17, 15, 15, 11. Then lordship may come to page 2.
2020.
2020 is there. That is
Mr.
Gibbon Saikia,
RP Hazarika Learned Counsel for the petitioner. In
2020
terms
was
of the directions passed by this court by the order dated 10/4/2024, has placed on record the merit list as prepared by the respondents for the post of Sahayak under Sipsagar Electric Circle APDCL Sipsagar. And therein it is seen that for the therein it is seen that 20 marks have been earmarked for the head educational / experience. Also, in the order dated 22/8/2023 passed by the Managing Director APDCL, it is seen, it was contended that the maximum possible marks of 15 under the educational and experience criteria was awarded to the petitioner. However, from the merit list as produced today by Mr. RP Hazarika, it is seen that for the said component, there was 20 marks earmarked. Also, Mr. Chaudhary to receive instructions in the matter and place the same before this court on the next date fixed. List this matter again on 1/5/2020.
Could it be after that?
When?
Was the second week of May?
6/5/2024. Full stop. It may be like this that experience in, for education, you have 10, you have experience 10.
Yes.
So just check up what it is.
I'll get the instruction.
Otherwise, you said full marks.
Yes.
So if it is full marks, then he is to be given not 15, but 20.
20.
And if he is given 20, just check up whether he comes in.
If he is entitled to 20 marks, then he will come in the frame.
He'll come in.
Yes. And then the people who've been appointed, they'll be necessary parties.
This you make a post. That will not interfere.
Code, your lordship. That is the main problem, your
That will not interfere.
yes.
Well, I'll place the instruction.
List the 6/5 likhi jana mode.
Deeply obliged.
Deeply obliged, your lordship.
I don't want to praise the matter, lordship.
But what about the suppression you have made here? You have suppressed things. You have resigned from that college. Not brought those things on record. Why? What should we do? You have made a categorical prayer that you're working till date, but you're not working in that school. Or you have a instruction contrary to that. Because they have filed an affidavit as well as an IA. And therein they have brought on record documents to show that you have resigned. And you have participated in the selection process with a permission from the IS. But those things have not been brought on record. Maybe the petitioner had not communicated that to you. Ask your petitioner why it is, and come back at 2. If it is a fact, we are imposing cost. Right? 2 o'clock.
Make your losses.
Today is not a good day. Today is not a good day.
This case is, my lord, your lordship.
Today is not a good day for Miss Devi. Today is a bad day.
Lordship, can you peruse the last part of the petition, see, page 60?
You want to do it today?
Then Friday, my lord.
Same thing.
Because in the morning I got bad order, that's why my mood has been.
Today I'll be bashed.
Case of
In the
job-
corridors, I'll be bashed today. Done. Tell me. Provincialized school.
No, this is a case of my lord dropped it,
Tell me.
LDA.
No, I don't know. You are a master of drop cases.
Then it was a-
Tell me one thing.
Yes,
In one school,
yes.
there would be a permission, say, normally 5 posts are required. But
No,
the
no, no,
school
not
managing
that, my lord. That is a different case altogether.
the school managing committee appoints 20 teachers. Saying we have students, we have appointed 20. Now, 5 were provincialized. So another 15 is dropped. Now, in terms of Jibendaka, all the 15 have to be provincialized or regularized.
Yes, my lord.
That's the law.
No, it was written in the law that the person who were left out as a drop, my lord, they can approach to the court, my lord.
I know that.
Yes.
But if there is no
That is
provision,
what we have come.
no,
before
no,
this
there is no
honorable court.
provision for a second post of LDA.
There is a provision, my lord. It's
Show me that.
written that they can.
Show me that.
My lord, I have not prepared actually, that's why. Thursday that.
On the prayer of Ms. A. Devi, list this matter again on 30 of
Thursday,
4/2024.
Only my presence may be recorded, your lordship.
Ms. P. Das, Lanet, Standing Council, Secondary Education Department is present. 30. Deferred.
Because recently I got obtained order from this honorable court, my
I
lord.
don't have the
But I have
guts
not
to
taken
dismiss
this.
2 cases of Ms. Devi on the same day.
I'll do,
Deeply organized.
Last occasion. It's not a. On 3-4, the lordship has asked some instruction from the education department as that is. Because we.
It's a provincialized school.
In that year 2023, that was.
Whither does it make?
Two
My lord,
teachers,
Here, my lord, the petitioner was appointed as a, my lord, Shiksha Mitra. Since 2014, he is not in work.
Okay, fine. This is what we want. We can dismiss the petition now. Wait for some time. Let the. Cannot, if she's not here, we're not disposing, she was pursuing the matter. We'll have it on,
Some other day,
then,
she may not come.
huh?
She may not come. Please.
Today, maybe something, we'll have it on a different date. then.
6th of May.
None appears for the petitioner on call. Mr. P. K. Bora Lanet, Standing Council Elementary Education Department has placed on record the instructions as received by him from the Director Elementary Education, which reveals that the school of the petitioner was provincialized while an order dated 18/4/2023. However, the petitioner herein is not entitled. However, it is contended in the said communication that the petitioner herein is not entitled for being considered for provincialization of her services as he was working as a Shiksha Kormi under a particular scheme and not a teacher of the said school. Full stop. However, in absence of the petitioner, counsel for the petitioner, this court would not like to further consider the issue today. Accordingly, list this matter again on
8th of May. Yes.
2/5. You're here on 2nd?
2/5, I'm here.
2/5/2024.
So let's see.
A copy of the communications
Can
dated,
it be?
if
Not
required,
little bit,
somewhat
2/5.
further also no problem. On 29th also. 29th,
Let's see. 29th, I have some difficulty.
30.
29th or 30, I have a difficulty.
1,
3rd May, I have no.
3rd,
3rd May.
3rd May, 3/5. Copies of the communication dated 21/4/2024 and 18. And the notification dated 18/4/2023 as produced by Mr. Bora, Learned Standing Council, Elementary Education Department is kept on record and marked as X and Y respectively. That's Sipsagar.
My lord.
Yes,
Well, they have given the undertaking and when they have appointed as per the decision of the cabinet decision, they have appointed, madam.
when?
That decision I don't have right now.
You have been appointed, Mr.
My lord, subsequently, we have
They
been,
have-
my lord, given the benefit of teacher,
Tutor,
my lord, as a tutor, my lord,
tutor.
as an assistant teacher.
Fine.
Now, my lord, what has happened in our appointment order, they have inserted a condition that we should give the undertaking that we will not claim pension as per the 2005 rules. My lord.
And that is, I think,
That is in under
protected
challenge
by-
in the
by this
second,
court.
yes, my lord. In the second writ petition, that particular clause is under challenge.
Hmm.
And this honorable court by of an interim order, my lord, has diluted that condition and allowed us directed to consider.
you file your affidavits then. Now, at least something has happened.
Yes, my lord, yes.
On the prayer of Mr. P. Bora Learned Standing Council,
Turning to the
Elementary
Etuning.
Education Department, list these matters again after 3 weeks, enabling the said respondents to bring on record their stand by way of filing an affidavit in the matter.
My lord, I have a small prayer, my lord.
Hmm.
Lord, we have allowed joining recently, my lord, and but pursuant to that joining, our current salary may be.
Current salary, that first salary, it requires certain processing.
My
If by the next date you are not getting it,
Yes, yes.
inform, we will.
Obliged. Obliged.
Also. The present writ petition was initially disposed of while an order dated 4/2/2021 requiring the respondent council to take the process of selection to the post of junior assistants to as advertised, while the advertisement dated 10/5/2018 to its logical conclusion. So, however, being aggrieved, the respondent council as well as the state had filed a review, being review petition number 20/2022 before this court. So they said review petition was allowed on 12/3/2024, recalling the said order dated 4/2/2021 passed in the present proceedings. Full stop. Accordingly, the writ petition was restored and it was listed on 1/4/2024. However, none had appeared for the petitioner. Today also, when the matter is called, none has entered appearance for the petitioner. Also, in the view of the above, the present writ petition stands dismissed for non-prosecution. Mr. P.K. Roy, Learned Standing Counsel, Assam Higher Secondary Education Council, and Ms. P. Das, Learned Standing Counsel, Secondary Education Department are present.
I know the counsel for the college informed me that he's on legs in court number 18.
Yes, Mr.
My lord, this is the second round of litigation, my lord. The first round of litigation, your lordship ordered.
The way you say, you are satisfied that this will be the last round of litigation.
No, I don't think so. At, Annexure 17, page 70, my lord. Earlier order, my lord.
The only issue here is that initial selection, whether it was a selection on merits or as contended by Mr. Nair, that whether it was a selection simpliciter. I think that's the word used. Simpliciter. I'll ask him what a selection simpliciter is. That's a different question altogether. Now, you project that, see, because of this selection simpliciter, as he says it, you were placed at serial number 1 and she was placed at serial number 2. Accordingly, you both were rendering services without any pay.
Without any pay.
Because you were at serial number 1, 2004, you were brought over to the regular. You were given some remuneration. And you were included in the acquaintance role. Same benefit was given to the private respondent in 2007. Now, the provincialization takes place.
Before the provincialization, our salary, that was, there is a.
You were drawing a higher amount than her because 2004 and 2007. Now, the matter goes up before the DLC, before you both are recommended as LDA.
No, I am recommended as senior.
No. When it goes before that, you both go as LDA. You get
senior LDA.
You get senior UDA and she gets LDA.
Right.
At that point of time, she has a grievance, right? She approaches this court, makes representations, approaches this court, matter is remanded back. Now the authorities proceed to consider the issue. And they say, I'll use the word used here, all brackets are same.
17.
The only bracket that is not same is the date of birth. And accordingly, she is given.
Yeah.
Right? Now you come to para 10.
Of the litigation.
Para 10.
That the petitioner states that on 30/1/2004, an executive meeting of the managing committee was held to discuss various issues of the college. After deliberation and discussion in the meeting, the resolution number 10, the managing committee resolved to give remuneration to the petitioner at the rate of rupees 225 per month, who was placed at serial number one amongst the LDA candidates as per resolution
Hmm.
number 4 of the managing committee dated 26/4/1997.
Hmm. Now come to page 27. Resolution number 4.
Type copy is at page 24.
No, I want you read the vernacular.
Vernacular, আজিৰ সভায় সত্যনীয় জাননীৰ ওপৰত
Hmm.
নিৰ্ভৰ কৰি
স্থানীয়
নিম্নলিখিত
জাননীৰ ওপৰত নিৰ্ভৰ কৰি নিম্নলিখিত
নিম্নলিখিত ব্যক্তিসকলক
Hmm.
নিম্ন উল্লেখিত পদ
সমূহত
সমূহত
যোগ্যতা
যোগ্যতাৰ ভিত্তিত
reference to merit,
merit.
right?
Now there is a dispute
With
Your-
regard
your
to that,
lordship
word.
had
And that has been resolved by the
translation department.
translation department. Now you take me to the pleadings corresponding to this in the writ petition, corresponding
affidavit
to
of
this
opposition.
by the private respondent and the college. That's the issue.
That's it.
Hmm.
I'll place respondent number 6 first.
Hmm.
Paragraph 3D
Hmm.
at page 89, madam.
8990, yes.
89.
Hmm.
The writ petition has annexed an incomplete minute of meeting of the governing body, State College, as annexed 2 to the instant writ petition. In this connection, the deponent state as follows. Number 1. The advertisement dated 24/4/1997, annexed as annexure 1 so and so, was published by the State College when it was in a venture stage. The deponent categorically states that the process initiated for recruiting the deponent, the writ petitioner, and others was a selection simpliciter solely on the basis of eligibility and was not on the basis of any selection or merit. The deponent, the writ petitioner, and the other were appointed pursuant to the resolution adopted in the minutes of the meeting dated 26/4/1997 of the governing body of the State College.
So that resolution is not disputed.
Resolution is not disputed. There
Proceed.
is a resolution. The deponent states that Sri Raman Methi and Sri Riten Methi, who were placed at serial number Gha and Gha in the said minutes dated 26/4/97, were selected as land donor family member, being eligible for appointment to the post of advertised, and was not on the basis of merit admitted position in the selection process. Further, the said Raman Methi and so and so in particulars of non-teaching staff of the college annexed to here too.
Now take me to that. This is the only thing. Rest are reiterations,
Madam.
right?
Now, resolution number 5 also, if your lordship will say of that,
Earlier one,
Earlier
page
one.
27. Yes.
here they have at 1, 2, 3, 4, fifth line, page 28, my lord. They have referred to merit list. Medha
Talika,
Talika.
Medhavi
So
Talika.
there was a
Talika.
Medha Talika, there was a merit list.
Yes. Yes.
Now, if I may please, rule 17 for a moment. my lord. Because rule 17 requires either a selection,
This, we are in the pre-provincialization stage.
Madam,
That's something which they can devise on their own.
they can.
So the only question is how you were placed at serial number 1, right?
So
Now come to the college,
my lord,
affidavit by the college.
affidavit by the college. The college at paragraph 5, my lord, at page 78. As regard the amendments made in paragraph 5 and page 78, my lord, paragraph 5. My writ petition, paragraph 5 was there. They say the deponent states that the secretary of the governing body, BC College, published an advertisement on so and so for appointment into post of non-teaching staff in the college, including 4 numbers of post of LDA, laying down the essential qualifications as HS exam pass, diploma in typewriting. Accordingly, the present petitioner, respondent number 6, along with other candidates, it was not just 2 persons. There were other candidates applied for the post of LDA. And then the governing body, by its resolution dated 5/5, it's 5/5 because it was signed on 5/5. The resolution was taken on 26/4, signed on 5/5.
resolved to appoint 4 number of candidates by resolution number 4, wherein the petitioner and the respondent were placed at serial number 1 and 2 respectively.
Now they bring in the concept of eligibility.
Simply so.
So whatever they say, neither the college nor the private respondent has disputed that resolution. That's the case. So if that resolution holds, then you are true.
I mean,
Yes, Mr. Nair.
My lord, here, my lord, from the vernacular reading, it was not a selection on merit, my lord, as lordship has. already-
Medhabi Talika.
That is on the second part. But my lord,
No, there are two things, Mr.
yes, sir.
Nair. If you come back to page 27.
27.
Read resolution number 4. আজিৰ সভাই
আজিৰ
স্থানীয়
সময়ত স্থানীয়
জাননী।
জাননীৰ ওপৰত নিৰ্ভৰ কৰি নিম্নলিখিত ব্যক্তিসকলক নিম্ন উল্লেখিত পদসমূহত যোগ্যতাৰ ভিত্তিত নিযুক্তি দিবলৈ সিদ্ধান্ত গ্ৰহণ কৰে।
So যোগ্যতা means something is there.
The eligible,
Eligibility, something is there.
whether I am যোগ্য or not.
That is one.
the
Now you come to
Five.
5.
5, my lord.
আজিৰ সভাই
আজিৰ সভাই বিভিন্ন
নিযুক্ত প্ৰাৰ্থীয়ে যদি চাকৰিত বিভিন্ন নিযুক্তি প্ৰাৰ্থীয়ে যদি চাকৰিত উল্লেখিত মৰমে বা ধৰণে হ'ব ভিতৰত যোগদান নকৰে
তেন্তে পৰৱৰ্তী
প্ৰাৰ্থীয়ে
যোগ্যতা আৰু
আঞ্চলিক ভিত্তিত মেধাৱী তালিকাৰ
তালিকাৰ পৰা something নিযুক্তি দিয়াৰ বাবে সিদ্ধান্ত
নিযুক্তি দিয়াৰ বাবে সিদ্ধান্ত গ্ৰহণ কৰে। কোনো নিযুক্তি দিব লগা হলে কৰ্মচাৰী কমিটিৰ অনুমোদন লবলৈ নিৰ্দেশ দিয়ে। লগতে উল্লেখ থাকে যে মেধাৱী তালিকাৰ আজিৰ পৰা 1 বছৰ ম্যাদ থাকিব।
My lord,
They use the word medhabi. Medhabi means merit.
my lord, that is on the second part,
No, it's a continuation, same day resolution.
my lord. But my lord, the original resolution,
Be that as
whether
it
this
may.
is there on.
Now, if this was there,
Right.
it refers to two concepts.
My lord,
One is the appointment made locally
my lord,
and the appointment made on merits.
on me,
Appointment made on merits is 1 and 2, you both.
my lord.
And locally is 4 and 5 because they had donated land,
Landowners, my lord, my lord,
right?
my lord.
Now, second issue, which you have not touched in your affidavit. It's a specific contention
Right.
that he was given the skill
Right.
basing on merit and also in terms of the regularity he is having.
Right.
This has not been
Right.
contested by you.
My lord, because my lord, that was not a ground for provincialization. For provincialization,
No, for the purpose of understanding
my lord,
that it was the petitioner who was considered to be senior all along.
my lord,
That statement was made,
Right.
maybe a wrong statement, but you have not disputed that.
my lord, we did not challenge that, my lord, because we were not aware of that at that point of time.
But when the writ petition was
came,
filed, you were aware,
we were aware, when the writ
but
petition
that
was
still you have not.
my lord. My lord, because we were under the impression, my lord, that cannot be a ground for the purpose of provincialization. For the purpose of provincialization.
It's seniority,
Only seniority,
seniority.
my lord,
And if it is merit,
my lord,
in the way resolution number 4 and 5 read together,
my lord,
because these two resolutions have not been disputed
my lord,
by anyone, even the college is not disputing.
my lord,
So if this is the prescription at that point of time,
my lord,
why will not the petitioner be allowed to continue as the senior UDA?
my lord, here, my lord, the selection, whether there was any selection of,
It need not be. Even if there was a concept of a selection there and he was held to be one,
Right.
without making a challenge to that, today can you
my lord,
go beyond that?
my lord, we have not challenged that particular one,
The
But-
director
my lord.
has taken up a new issue altogether.
My lord, that was pursuant to a direction from this honorable court, my lord.
This order, this court did not tell them
No.
that do it in this manner?
No, my lord.
Why was this things ignored?
My lord. This particular thing, my lord, that is for the director, my lord. But
We'll
insofar
interfere
as
with that.
we are concerned, my lord,
We'll interfere with that.
my lord.
We will make an observation that there was 2 resolutions of this to this effect.
Right.
Now, the director has not been disputed by anyone. Interpretations may be different, but the resolutions per se, existence has not been disputed.
Right.
So the director now will take into account resolution number 4, 5 and the statement of the petitioner with regard to grant of pay 2004 and 2007 and thereafter decide the issue.
Fine, fine. And the director would look into the records, my lord.
Online, I'll not say much. And tell me, what is this new concept? What was?
Simplicity.
Selection simpliciter. What is that?
My lord, on the basis of eligibility. My lord, the entire line, my lord.
When it is election simpliciter, selection simpliciter,
My lord.
still there is a selection. And
My
if
lord.
it is a selection, maybe on the basis of eligibility, maybe on the basis of color, maybe on the basis of size. It is a selection. There is a placement.
My lord, the entire line, entire sentence, my lord, selection simpliciter solely on the basis of eligibility, my lord.
That is enough. That is enough.
Right.
So by making that statement, you are also admitting that there was a selection. Selection can be on any basis. He might have got, the eligibility was 50% in
Higher secondary.
higher secondary. He got 60, you got 55. So selection both through.
My lord.
Interesting word.
My lord, the
Selection simpliciter. This I'll remember for a long time now. Okay. Hearing concluded. To me, I Hearing concluded. To me, I said the education did you disposed of.
deep level.
I thought he was not here.
In this case, my lord, no affidavit has been filed, my lord. Kindly say I filed representation before the director of pension, my lord, page 49.
The director of pensions. Who is appearing for a director of pensions?
Government, my lord.
Mr. Deori.
Deuri, my lord.
Mr. Deori, learned counsel appearing for the director of pensions. Director of pensions.
Page 49.
Respond number, Ms. D. Das Burman, learned counsel appearing for the director of public pension and public grievances, Assam, shall on the next day place on record the stand of the said respondent with regard to the claim of the petitioner herein that you are claiming 3760.
My lord.
You were given 3580.
My lord.
What is the mistake?
But mistake, my lord, and similar situated person already received the same without any recovery.
Now, if we direct, his recovery also will be made.
My lord.
You are not entitled.
But
See,
1196, my lord,
there will be no recovery. But that correct fixation can always be made.
my lord.
We will direct that no recovery. Recovery has not been made from you. Has it been made? Any amount recovered?
No, my lord.
Only that correct fixation.
My
What is the error?
Correct fixation without hearing, my lord. My lord.
It not me. Show me the law. Show me the law. There are decisions of this court. No recovery, but correct fixation. It's not a path. You know, you have done.
As per my lord petitioner, the graduate pay scale granted in the year 1196.
Show me
my
the
lord.
error.
And my lord, kindly see my lord on this state, my lord, stand. Kindly see page, my lord,
41.
41, my lord,
I'm holding it.
my lord. And during that
Has
period,
this
I have
amount
not
been
received
recovered?
any arrears,
95598 recovered? No.
my lord.
Huh?
No, my lord.
Then. Elijah, on the next date shall place on record the stand with regard to the claim of the petitioner that while his pay has been refixed, however, in case of a similarly situated person, namely
Paramananda Padgiri, my lord.
Paramananda Padgiri, the said revision was not so made also. Ms. Das, Baman, madam, you just received that. I don't think so there is anything, but anyway, he has raised the grievance. You get that instruction, we will close it. You are appearing for?
Seven lordship. Fixation is concerned lordship, the concerned department, education
No,
department.
no. It is done by you. You ask them, they'll give you that instruction.
I'm for seven.
For?
Seven lordship.
AG,
No, my
Seven,
lord.
respondent number seven.
who is respondent number 7?
Administration lordship. Administration.
Administrator of that school, my lord, concerned school, my lord.
School lordship.
He has no role, my lord. That's
Your name?
MS Alam.
Huh?
MS Alam.
MS Alam, appearing for the respondent number 7 is present. Just get that instruction.
Fix the matter after.
When do you want it? We'll have it on 8th, 8/5. List again on 8/5. 2020.
Not eight, my lordship, nine.
9/5. 9/10.
Yes.
10/5.
Yes, lord.
10/5.
Public.
My lord, it's a B Purka is on legs, my lord. Can it be after some time, my lord? There is another item, my lord.
Oh, my God.
41 also, my lord. Will be taken after some time.
Okay. After some time.
My lord.
Time being going to do.
But Mr. M. Khan also on that, my lord. After
Time
some
being,
time.
time being. Mr. Bhuya, the private respondent has not entered appearance.
6 has not entered. Service completed, my lord. Because, my lord,
Yes, Mr. Mojumdar.
university trying
Has
to,
this private respondent completed her PhD
no,
Prior to the
advertisement?
that
It's all vague. His categorical statement, she has not completed.
yes.
If she has not completed, how can that eligibility with regard to that open paper
Open lordship.
be done? That's the only question we'll have to see. When?
Whether she had completed, my lordship will have it
Or
after.
is it from the master degree? Whether in the master degree, if you have that paper, then that will satisfy. And it is his case that it is not there.
Not.
And you have relied upon the papers she has presented in the process of her PhD thesis.
Yes.
So naturally, in her MSc paper also, she does not have that. Get these 2 instructions. When?
Lordship will have it after the 6th.
And lordship is a
8th or 9th.
He has certain fixed dates for certain cases.
and lordship and
Mr.
also,
Bhuya,
also,
Mr. Mojumdar, when he gets a case, he also has the horoscope of that case.
I am, but lordship, along with allocation of mark, even in the interview.
I think this 2 is enough. List this matter again on 8/5/2024. Mr. R. Majumdar shall apprise this court as to whether the respondent number 6 hearing had completed a PhD course and awarded the degree before the last date of submission of application in pursuance to the advertisement in question. Further, Mr. Majumdar shall also apprise this court as to the manner in which the respondent number 6 was held to be eligible to participate in the selection process, more particularly when the posts in question was for specified specializations.
High law, high law.
37.
Date may be given, Lordship.
Oh, no, I gave it 8. Mr. Majumdar, 8 is enough. 8-5 falls within that parameters.
My calculation would be 15, but since it has fallen from Lordship, it's 8.
I know.
Bless.
May I please, Your Lordship?
Ah,
Lordship, kindly peruse the order dated 38th January 2024.
38.
January 2024.
Is 7, no? Okay. They have not brought, you establish.
This may take up in the next week, madam.
No. And if we proceed to hold in our favor, your departmental, because we have given you,
And I have received
the time is granted from 24 to 23. After having taken this bench from 10-1 onwards, this is the 4th day. Okay. Yes. Make out your case. Want some time to formulate?
Lordship, petitioners are,
You want some
Okay.
time to formulate? We are disposing it of today. You want to some time to formulate
Yes.
and have come back at 2. Formulate your prayers
Lordship.
and satisfy this court that you have a legal right.
This is effectively the second round of litigation. What had happened was the services of there was a school which was provincialized.
Hmm.
Now the services of the private respondent was provincialized as a subject teacher.
Where is that DSC minutes?
That
DLC.
record is, that was called for, Lordship. May I-
That's what I'm saying. Yes.
I am paying for yes, number 7.
7. Rajan Patak.
Yes, yes.
Rajan Patak. Yes. Where is the records? Yes, Mr. Forget the records. You tell me your story. What is your case?
My case is that
You are the headmaster?
initially I was as an assistant teacher.
Then you are a
Then in
social studies
2007,
teacher?
I've been promoted.
No,
as
you are
one of
social
the
studies?
Social studies.
Petitioner is social studies?
No, petitioner is language, Lordship.
Show me that.
Lordship, I have some document, Lordship. I have not.
Where is the,
So while I'm saying, Lordship, at the time of provincialization of the school,
Hmm.
the headmaster or the head teacher of the school also, they have to forward the particular.
Hmm.
But while they forward the particular,
Hmm.
of the particulars, it is dated of 30th of May 2017.
Hmm.
Here itself says that Nibharani Boro, that is the petitioner,
Hmm.
she is teaching Assamese, Lordship.
Okay.
So for the.
That means page 49 of this court order.
Yes, Lordship.
Right?
No, Lordship.
Page 49.
Lordship.
Third, as per physical verification report, have you got it?
Yes, yes, the third paragraph.
Mr. Pathak, have you got it?
Yes, yes, Your Lord.
Read that.
As per physical verification report of the Office of the Block Elementary Education Officer, the respondent number 7 is the headmaster of the school, having been appointed on 27/1/2005. The respondent number 8, Dolly Rani Dotto, is a language teacher, having been appointed in 17 to 1995. The petitioner number 1, Nibharani Boro, is a teacher in social science.
Science. Appointed on so and so.
And yes.
So
That is why,
there is a finding of this court,
let's say it is based on the verification.
be that as it may.
Yes,
Yes.
that is why report has been called for.
No, tell me your story. You have given the particulars.
My-
What particulars have you submitted?
That's it.
Why have you not filed an affidavit here?
You file affidavit.
No. Show me. And respondent number 7, Rajan Pator,
Yes,
is a social science teacher.
social side, Lordship.
You are social science. She is social science.
No, he is language, Lordship.
This order
So
of
the
this court.
report, this is the report.
Show me.
This was not denied, this was forwarded on 30th of May 2017. And on the basis of this report, Lordship, they have recommended. Lordship, permission, I can bring this up.
Is there a requirement? A permission is required?
Last second, Lordship, they took time, Lordship. 30th of May 2017.
No. Where is the other thing?
It is from the office of the, because this is the report of the physical verification done by the BO, Block Education Officer. So that is why the report has been called for last occasion. All along my claim is that I am the social science teacher, and so for the petitioner's concern, she is a language. So report from the district court is called for.
No need. We don't want anything.
Report on it. Last one.
The DLC minutes are not here.
Not there, Lord. Because it is the authority, Lord. No else.
Supervision committee represented by the deputy commissioner.
Hmm?
Represented by the deputy commissioner, district scrutiny committee represented by the deputy commissioner. So, my lord,
You don't have records of that.
Yes.
Huh?
my lord.
Ms. Fukon?
Yes,
You
my
don't have records of that. Shall I record it?
lord. Yes, we have the six report.
Where is that BEO's report basing on which it was done? That finding of this
Physical
court?
verification
This is
report,
not annexed.
otherwise there is a copy at page number 38.
38.
38.
No, how did this court come to this conclusion?
There is no.
This does not reveal.
Yes, that's 38.
I think it says as per physical verification report. So perhaps this is the physical verification report it is referring to.
That claim is based on the subject teaching also. But there is
Because
no subject
the
teaching.
paragraph starts as per
As per.
physical verification report.
On the next date, fixed, Ms. N. Fukan, as well as Ms. D. Das Borman, additional senior government advocate, shall place on record the recommendations of the district level scrutiny committee,
District scrutiny.
the district scrutiny committee
Kamrup
pertaining
Metro.
to the
Arun Shankar Bhaduri.
Orun Sanga Badhuri Balika Vidyalaya. Tepesia, Kamrup. So, and also the recommendations as made by the state level scrutiny committee in the matter. So, list this matter again on 6/5/2024. Interim orders passed earlier to continue. Let us get it.
Yes, yes. Okay. May I take that?
Thank you, Lord Chief.
Yes.
File a reply. Can it be on next Friday or Monday? Tomorrow I'm filing it.
You're filing a reply to this.
Yes, madam. Right, definitely.
But they have filed a very detailed one, affidavit.
Detail.
State, Mr. Kolta, you are not filing it, very on it request.
Please not.
You can assist this court.
Yes.
Okay, Ms. Nsukia, Ms. Nsukia, Land Council, submits that that the respond number 2, 3, and 4 have filed an affidavit in the matter on 1/4/2024, and accordingly, she be granted a week's time to bring on record the rejoinder thereto on behalf of the petitioner. So accordingly, list this matter again on when? When, madam?
Friday or Monday, madam? If possible, Monday.
Still heard a little bit, but this will require some hearing.
Yes,
Yes.
madam. Yes.
We'll have it on
May-
14th. 14th. 14th only John, I know it did. But yeah, I too. 14th. 14th. 14/5.
14 May.
14/5/20.
Obliged.
The learned parties are at liberty, the parties are at liberty to bring on record their pleadings on or before the next day.
Obliged.
Time being. Yes,
Thank you, Lord.
anything?
Lordship, I think as implemented.
You have got your registration done?
No, my lord,
No. For the internship.
internship was already over, my lord. Rural posting.
Rural
he has
posting, are you
already
through?
applied.
No,
He has applied.
she has applied.
And now the applications for MD have come out. And the date, the period between which it can be applied is 16th April to 6th of May. So 6th of
Yes,
May is
Mr.
last date.
What is the stand?
Not mine,
No, Mr. Budde, any instruction on your part?
but they are the one who left.
You are the one who has to do it.
Lordship, we have just been implemented, Lordship. The first time I've been served copy, I'm appearing, Lordship. Few days may be given, I'll get the instructions, my lord.
Get it before 6 because he says 6th is the date for that PG.
Last date, and that too, my lord, it is mandatory that the provisional registration certificate needs to be uploaded.
Let it
So-
not finish, my lord.
No.
Later I have 1 day additional, my lord. The wait till 4th, my lord.
You keep your applications ready.
This is a
You keep your
My lord,
applications
Let
ready.
it be on 4th, my lord.
Keep your
Fourth
applications
is a
ready.
Saturday, 4th May. It's a Saturday.
4th
List this
Saturday.
matter again
Third,
on 3/5/2024. No, 2/5/2024.
my lord.
Second,
I have some difficulty, my lord.
and 3, my lord.
1 or 3, my lord.
3/5/2024.
Online.
6th is the last date.
Yes, my lord. 6th is the last date. And
1/5/2024.
my lord.
By which date the respondents shall bring their stand on record either by way of filing by filing affidavits and or placing on record written instructions received from the authority competent to issue such instructions. I'm giving you option either way.
Yes, my lord. On first, I'll place the instructions on the.
Please, that will do.
Written instruction on it. That will
Does
do, my lord.
show us this legal status. That will do.
Yes, ma'am.
Thank you, obliged.
There's one third. Of
First.
One.
It's been made for-
Because if it is on 4th, 3rd, and we pass some orders, if it is not uploaded, then that student will be in trouble.
My lord.
in the
We'll have it
meantime-
on first. So I get a day time.
Yes, my lord. Yes, my lord. And my learned friend, my lord, she may provide me page number 36 to 43 of the petition not legible. So
I-
I'll-
You give him a fresh copy of the petition.
Yes, my lord. If you guys.
My lord, we have taken instruction.
Hmm.
We'll agree to anyone other than from the Department of
Department.
Defense. And my lord, and of course, not the last one who is already appointed.
Hmm.
Actually, our difficulty is we are from Itanagar. And the gentleman at serial number 21 of the list is in Pune, my lord. We want somebody around, my lord.
Mr. Chaudhary, nowadays,
That's true.
I have been seeing persons traveling from here
Correct.
down to the South Bombay for attending.
More particularly, WhatsApp has connected people like
Everybody.
anything.
You have any written thing for that? No, or we'll just
I'm
record.
handing over this list from this Manla other than 21 and other than Ministry of Defense, anybody.
We'll have to hear Mr. Gupta,
Could I see him?
Mr. H. Gupta.
Other than 21 and other than Ministry of Defense, my lord.
21 and Ministry of Defense.
Yes.
You are agreeable to others.
Yes.
Mr. Das,
Mati diya hai.
Mr. Das,
Or
be
maybe
here.
at 2
Just
o'clock.
have him at 2 o'clock.
Oh,
Don't trouble Mr. Chaudhary. You be here at 2 o'clock. We'll record your name, Mr.
My lord. Mati diya.
Dutta was But the losses of the court, I was trying to go into that issue.
Yes.
It would have been it was a really interesting issue.
Yes.
Maybe next time some other issue.
This is a contempt proceeding, Milad. This is regarding payment of advance increment. Others are getting, we are also BA degree holders, Milad. We are not giving.
Yes, Mr.
So we file it petition and the honorable court.
Why is Mr. Your secondary or elementary?
Secondary, Milad.
Secondary.
And ordering, Milad. Page 62.
Yes,
Why are you not considering his case?
May pleases you, Lordship. Kindly matter me fixed on Friday, your Lordship.
Why? So it'll happen
Your Lordship, I need to obtain instruction, fresh instruction.
on the prayer of Ms. P. Das, who undertakes to obtain instructions in the matter with regard to the status of implementation of the directions passed by this court-wide order dated 10/2/2021 in WPC number 772 of 2021. List this matter again on 29.
I'm appearing on behalf of SMT 60.
29.
Deeply overlaid.
29 for.
May I please. But in this case, what happened, my lord? They have
Language teacher.
my lord, they have passed 3 orders, my lord, but they have not completed the order till date, my lord. Will you kindly have a look, my lord, page 11.
You are Shahjahan Ali.
My lord.
Shahjahan Ali, social studies.
My lord, he is a Hindi teacher, my lord. But his name was wrongly forwarded as, my lord, social studies teacher. And district student committee recommended his name as additional teacher, my lord. And he, my lord, approached the Honorable High Court, my lord, and this Honorable High Court has passed this order, my lord. Page, my lord, 31, 11, page 11, my lord. Para 6, this is the order, my lord.
This is dated 18/1.
My lord.
So they have come up with a order dated 12/3.
Well, my lord, this is for the last order, my lord. My lord, they have passed 3 orders, my lord, in compliance of this order, my lord, but in none of these orders, my lord, they have complied the High Court's order, my lord.
Order, when was the compliance orders?
My lord, first order, my lord, they passed in 26 August 2023. 22. And
second one?
Second one, my lord, 13/10/23.
13/10.
My lord.
You have a copy of the 13/10, yes.
And my lord, last order they have, my lord, passed, my lord, 12 March 24.
Okay, let us see what.
In all these orders, my lord, they have considered my case as additional teachers, my lord.
Where is the willful and deliberate violation? Where is the willful and deliberate violation?
My lord, they are not complying, my lord.
What compliance? This court said, find out. If you are a language teacher, consider. At least in that order dated 13th, they have done it.
My lord,
1310. Just
My-
see. Paragraph 2, paragraph 4. They have done it. Maybe wrong.
My lord, your lordship, kindly have a look, my lord, to page 11, paragraph 6 of the order, my lord. The direction was, my lord, to consider my
You
case.
be disposed of the reader to consider the claim for as language teacher, so and so, so and so. In doing so, they shall examine from the records to when he was appointed for what subject, and if the record so and so, so and so. If otherwise eligible, the director to pass a reasoned order.
My lord,
Right?
my lord.
So the discretion
my
is upon the director
My lord, they are
to
not
make
considering my
an
case.
inquiry. They made an inquiry.
My lord, they are considering my case as additional teacher, my lord.
1310. Clarification.
So that is, my lord, that order is not with me, my lord.
You told me 1310 they was considered. That was considered on 1310.
Lord, let the matter come up next week, my lord. Lord, they were supposed to file affidavit annexing
Forget
that
it. Forget it.
documents, but they have not handed over that documents to me, my lord. They were supposed to file affidavit.
Take file 2. You go through from here.
Then at 2, my lord.
At 2.
My lord.
Yes, Mr. Bora. What do you say?
My lord, here, my lord, petitioner name was dropped initially as because petitioner passed the higher secondary examination in Bengali medium. It is why his name not be recommended because petitioner asking for appointment as Assamese.
No, but under the, why was his case not considered under 2017 as tutor?
Abstraction by
Yes, madam. What is your case?
His name was recommended by the District Elementary Education Officer Hailakandi,
Hmm.
and a report was sent to the director
Under the 2011 Act.
under the 2017 Act.
Where? Page?
Rashid, sorry, my petition is misplaced today. So let maybe pardon next week. But if the second copy is provided to me. then-
Second copy. Second copy to DDO. Hai? Second copy to DDO.
Okay, no.
Second copy.
Yes.
It's here. This. You want an order like in page 53.
Yes, my lord.
Consider his case.
Yes, my lord, that may be considered because he has acquired the
Because you say that because on the date he was appointed, he was underqualified.
other.
You refer to that is not the requirement of the Act. The Act says on the date of consideration, he should have the following content.
as per the 2017 Act.
That's all.
Yes.
Let the district authority place
She will submit a appeal before submit a representation before the director,
Yes, ma'am.
explaining the position. The director then will require the matter to be placed before the DLC, and thereafter the matter will proceed in terms of the Act. Right?
Right.
Next.
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 This is a
Music teachers.
music teacher, but
Here you don't have the recruitment number of students. How can you be considered?
no, my lord, in my
2017.
17 Act, my lord.
Hmm.
And the number of student in 2017,
17. Page 31.
No, page.
Six
20
number,
Page 27, my lord.
27.
Column 5. Numbers of students appearing in SSLC essay examination is subject to classical subject during last 7 years. 2014, there is a 17 numbers of students. 2015, 23. 2016, 10. 2000.
No. 16, column 16 you see. 2017, 6.
But under 2017 and last
It is
3 years.
2017.
Yes, madam.
Even if I take last 3 years, still it will not be.
But in 2022, there is a.
It will not be. Act requires in a particular level.
117. But now it is increasing, my lord.
Let it be 100 today, but the act requires in a particular manner. How can we go beyond that? Show me. How can we go beyond that?
While the petitioner submitted his document before under 2017 Act for provincialization her service in 2022, that relevant point, that 3 years, that is 2014, 15, 16 to.
See the act. Show me.
Yes. Section Rule 3. Rule 3(7). Page 1110. For provincialization of service of one teacher, or as the case may be, is subject the 4 subject in case of Bhansar High School, Bhansar Madrasa, and Bhansar Higher Secondary School or Bhansar Senior Secondary. At least 10 students must have appeared in the last final examination in that particular subject from that institution.
No, yours will be covered by 4.
That is
1, 4, 2, Roman 4.
4 to Roman. 4 to Roman 4. At least. 4 to.
In case of teachers or tutors for special subject like Sanskrit, Arabic, Hindi, craft teacher, music teacher, the number of students appeared in the concerned final examination like HSLC, HS conducted by the SEBA or so and so as the case may be, shall not be less than 10 students in each class per year during the last 3 years. Last 3 years per year.
That is under 17.
17 rules.
That
So
means
if you come back to your that prescription,
when the
17, 16, 15.
14, 15, 16.
No, 17 is the last examination.
17.
Before, yes, there is a decision. There is a decision of this court
That's
that the last final examination would mean
17.
the HS exam or metric exam of 17.
17.
So if you come to page 31 now,
31.
serial number 4,
Is
17 is
numbers.
6.
6 numbered. But
So
if we kept the 14, 15, 16,
that you cannot take.
that's
That
he
you
is still
cannot take.
continuing in a service as a music teacher she is the only teacher. And this time she is also conducted the examination as an external examination.
Okay. Other two also same issue.
No.
Uh,
Ajay
Ajay Fukan and Kalpana Bora, same issue.
Ajay Fukan is different, my lord.
Ajay Fukan, 7.
Different, my lord.
Now next to you.
No, my lord, 7546, there is a, in 17 on 7, my lord.
In 2017, it was 7.
16, 10, 15, 15, 10.
And in the third one,
Third one is.
Kalpana Bora,
Kalpana.
sorry to the option.
But here there is a mistake.
In my lord, WBC 7596,
Hmm.
page number 52.
Hmm.
Here, my lord, Kalpana Borra, music teacher.
Hmm.
In the year of 2017, enrollment is 4
Hmm.
and 2016, 9. So low enrollment is there, my lord.
All the three low enrollment.
In this case, enrollment is less. But
What can be done? They'll make an application, you consider?
other,
Make an application to the government, you consider? Is possible.
but in
Maybe
the.
go for appeal, my lord.
Hmm?
Maybe go for appeal, my lord.
That's not appeal, they'll file an application before
Yes, yes, they may.
the commissioner, the secretary, Department of School Education.
Yes, yes, yes,
He will consider
yes.
the respective facts
Whether eligibility criteria is.
that would be determined.
Yes. ma'am.
47, 48, 49, 50. This was the file determined meeting.
Must have.
Mr. Lordship.
Seen the office note dated 19/4/2024. The service of notice upon the sole respondent is not complete. Although notice was issued on 25/9/2023. In view of the above, the petitioner to take fresh steps for service of notice upon the respondent. Steps within 2 working days.
I'm on.
Yes, Mr. Bora. Your affidavit has still not come on.
My lord, this is the document.
Give a copy to Mr. Das.
I have already furnished.
Ask Mr. Das to apply his mind.
Lords.
Mr. S. Bora, Learned Standing Council BTC has submitted that while a notification dated 4/4/2024, a committee has been constituted by the Secretary, Bodoland Territorial Council, Cockrazar, in pursuance to the orders passed by this court-wide, in pursuance to the directions passed by this court-wide order dated 16/2/24 in IA bracketed C 2082/2023. Also, a copy of the said notification dated 4/4/2024 is kept on record and marked as X for the purpose of identification. Also, in view of the said position and the committee having been so constituted, on the next date fixed, Mr. Bora shall apprise this court the progress as made in the purpose in the progress as made with regard to the identification of the persons so involved in making the illegal appointments of teachers. List this matter again after a month, 4 weeks on please advice.
Let it be on first part of June, my lord.
24th of May,
25, 2024. On the next day, Mr. Bora shall submit a status report with regard to the process as adopted by the committee for the inquiry undertaken by it and the progress as made as of 17/5/2024. in the matter.
Fixing on.
We are fixing it on 20th.
deeply obliged.
May it pleases your lordship, instruction received your lordship, seeking your lordship that UDICE report from SSA, your lordship, and the same report has been received during the year 2014, 15, 16. Now the report has been received and the matter will be placed in the state level security scrutiny committee meeting, your lordship, which will be held up after the code of conduct will be uplifted, your lordship. I would like to place it. Unique dice report has been received, your lordship, and the same will be placed.
Yes. Close the matter. The petitioner hearing, who is a serving teacher
Kawadanga High School.
of Kaudanga High School, has instituted the present proceedings with a prayer for a direction upon the respondent authorities to take into consideration the report as submitted in the matter by the District Scrutiny Committee, Doran, wherein it has been recommended that the petitioner's service be provincialized. Full stop. In terms of the directions passed by this court by the earlier orders, Ms. P. Das has brought on record, has placed on record a communication dated 1/4/2024 received by her from the Director, Secondary Education Assam, by which it has been intimated that the process of collecting the UDICE data and also the number of students as appearing in the HSLC examination during the years 2014, 15, and 16 has already been received by the respondent authorities, and now the case of the petitioner would be placed before the next meeting of the state level scrutiny committee, which would be scheduled after the model code of conduct presently in operation is lifted. Also, accordingly, the grievance as raised by the petitioner for having his case considered, for having the district report of the recommendation of the district scrutiny committee considered, has already been taken up by the respondent authorities, and accordingly, the present petition stands disposed of, requiring the director to place the recommendations as available in the matter of the district scrutiny committee, along with all other requisite particulars before the state level scrutiny committee for its consideration, and thereafter the matter be processed strictly in accordance with the provisions of the Act of 2017, Puratuni Kiriba 17, for the purpose of provincialization above purposes as per the recommendations of the state level scrutiny committee. Dubar is the second to it. With the above directions, the writ petition stands disposed of.
Time limit may be.
Deeply obliged.
After the thing,
Your lordship, one
the
matter.
above exercise now as required to be carried out by the authorities shall be so initiated and completed within a period of 6 months from the date of receipt of a certified copy of this order, or from today, 6 months from today going.
Hello.
My lord, office note dated 19/4 indicates that notice has been sent, my lord. On 19 only.
Office note dated 19/4. (2024) reveals that the notices have been issued on the said date. So accordingly, list this matter again after 4 weeks, along with a report with regard to the status of service of notice upon the sole respondent.
Hello.
There's an application for my stay vacation. There's an IA 734 of 2024, my lord, which I filed for vacation of the interim order dated 11/1/2022.
Where is the
My lord, 734, my lord.
Writ petition.
734 of 2024. Now, if your lordship kindly turns to the last order, the order dated 13/3/2024.
13
13/3/2024, my lord.
in the IA.
That's the last order. Second paragraph. Having considered the submissions of the learned counsel of the parties as well as the records placed before this court, I am of the prima facie view that the claim of the petitioner by projecting the respondent number 6 as a language teacher may not be correct. Even if the interim order dated 11/1/2022 is allowed to continue, no fruitful purpose would be served or any irreparable loss shall be caused to the petitioner, my lord. But to give him a chance, the matter was adjourned. Now, my lord, may I just point out,
My lord, I apologize for the interruption, my lord. So today itself, I have filed an objection, my lord. That is not on record, perhaps.
now, my lord, may I just point out, my lord, initially I was
You are
appointed,
for the applicant.
I'm for the applicant.
You are for the writ petitioner.
He's enjoying the stay, my lord.
Okay, fine. Give me the particulars.
My lord,
You are,
I'm my lord.
what is your
Renu
name?
Bormon.
The party's name?
I'm Renu Bormon, my lord. Respondent number 6.
Renu Bormon.
The respondent number 6, my lord.
Date of appointment?
9/2/1993, my lord.
929.
9/2/1993, page
Working
number
as?
50. And my lord,
Working as
I was my lord, assistant teacher, my lord.
assistant teacher teaching the subject of?
In the mathematics, I primarily teach mathematics. I'll prove it from the documents placed on record.
Maths. Show me. Show me that documents
That document, my lord, will find at page number 24
of the
it's-
IA.
of the IA. It starts at 19, my lord, but it's a physical verification report. And the relevant portion, my lord, will find at page 24, my lord. Page 24, serial number 3, my lord. Serial number 3 is the teacher name, teacher number 1, Renu Bormon. Page 24 of the IA, my lord. 24. Serial number 3, my lord, teacher name, teacher number 1, Renu Bormon. That is me, the applicant. And below, my lord, serial number 9, date of joining in service, your lordship will kindly note, my lord, 9 February 1993. And my lord, serial number 14, main subject taught, your lordship will kindly note, my lord, mathematics. Insofar the writ petitioner is concerned, my lord, your
is Kalyani Devi.
Kalyani Devi, my lord, teacher number 3, serial number 3, my lord, and date of joining in service, your lordship will kindly note, my lord, 16 March 1994.
Mathematics.
So admittedly, she is junior to me
Mathematics.
and both are mathematics. Whereas, my lord, if your lordship kindly turns to, and I was, my lord, provincialized, page 25, my lord, the next page.
I got it.
And my lord, if your lordship kindly turns to the order of which we are seeking a vacation, your lordship will find at page number 12, my lord. It starts at page number 12. In fact, the relevant portion is at page number 13, paragraph 4, my lord. May I just read out? The petitioner is a social science teacher in Pioli Pokon Nagor, having appointed in 16/3/1994. The respondent number Renu Bormon is the English teacher of the same school, having appointed on 9/2/1993. So completely incorrect projection of facts was portrayed, my lord.
Okay. Show me your objections.
And my lord, one just last point, my lord. There's an alternative statutory remedy available under the Act.
Show me
Under
the-
section 14.
show me- From your writ petition, show me what is your basis?
My lord, in writ petition, my lord will turn the page 15, my lord. 15, my lord, that is the particular of pieces, my lord. along with-
Submitted by you yourself,
My lord, by the headmaster, my lord.
Renu Bormon.
Yes, my lord,
Yes.
by herself, my lord.
Yes, Miss
My lord, the
Bormon.
petition-
Here, respondent number 6 is Renu Bormon,
Renu
English.
Bormon. English, my lord, and she is her
Nirupama De Kalyani Devi, social studies.
social studies.
Yes.
My answer to that, my lord, page number 15, your lordship will kindly see Renu Bormon, and your lordship will kindly see the date of joining, 9/2/1993. And Kalyani Devi, serial number 3, my lord, 16/3/1994. And
So, Mr. Borua, you accept this, that you have submitted this?
my lord, this was
Yes or no?
no,
No,
because
you have
this-
not submitted this.
no, this is not the final.
You have submitted this or not?
No, this was submitted.
This is your signature. Do you dispute?
No, this was submitted, my lord. There's no dispute in that. But then, when it was finally recorded, as per the records, your lordship will find the Dias code at page 24. So therefore, all I'm saying, my lord, there is a dispute.
I say everything here is wrong. You cannot disclose your own particulars in a wrong manner.
My lord.
Can you? You have said English here. Why this whole thing?
No, if your lordship kindly sees page 15 once more.
We are not vacating.
Renu Bormon.
We'll hear the writ petition.
So
We'll hear the writ petition.
at the end of the day, my lord, whether what is the
I'm only asking you whether you dispute page 15.
page 15 has been dealt with. If your lordship kindly sees my reply, I'll just point out what is my pleaded case. Page 15, that these particulars are page paragraph 3. And if your lordship kindly takes up my affidavit for a moment, affidavit which was filed on 16/8/2023.
I'm holding it. Come
My
on.
lord, if your lordship kindly takes page number 39 of my affidavit in opposition, that with regard to the statements made in paragraph 3 of the writ petition, the answering respondent humbly begs to say that the same are incorrect, baseless, and completely misconceived. As such, the same are categorically denied. It is categorically denied that the answering respondent number 6 teaches English at the cost of repetition as established above. It is herein categorically reiterated and reaffirmed that the answering respondent number 6 is the head teacher of the concerned school and our main teaching subject is mathematics. Clearly, the writ petitioner has
Okay,
resorted
now
to
tell me
completely
why
incorrect
this
position of
projection
fact.
was so made
My
in
lord,
page 15.
page 15. So,
You have not dealt with that there.
so my lord,
Tell me why this was made.
this was my lord, a tentative list, which
No, this
because-
is the list which is
but
submitted.
what is the ultimate product?
We are
Ultimate-
not concerned. We are concerned with the list prepared by you yourself.
My lord, if your lordship says page 15, your lordship will see.
Have you disputed this?
No, but that is what I have. My categorical statement is that I primarily teach mathematics.
You dispute this signature, Renu Burman.
Insofar this page is concerned, let me take my
No,
instruction.
no. You had your instructions. You have filed a reply.
I filed my
Then-
reply. And in the reply, I have stated that I primarily teach mathematics.
You have not said that this projection herein is wrong. Come to annexure 3. Wait 1 second.
Page
Let me see that. You can't change your stance as per your convenience.
My stand
you?
I have placed.
Yes. Come to page 5.
Page 5 of the writ petition,
Writ petition.
my lord. Page 5.
1, 2, 3, 4, 5, 6, 7 line from top. The
Page-
staff pattern of the petitioner school along with detailed information of the school had been submitted by the headmaster, that means you, before the concerned authority by the educational and professional so and so, dated 31/5/2017. Now, what is your reply to paragraph 3?
That your lordship will find at page number, my lord, page number 39. Page number 39, paragraph 6. Page number 39, paragraph 6. That with regard to the statements I have just read out, it is categorically at the cost of repetition. It is
No,
categorically.
you have not said that you have not prepared this page 15.
No, if your
Did you
lordship,
prepare it for fun?
no,
Then,
for whatever reason, my lord, it was prepared.
whatever
the-
reason,
At the end of the
Mr.
day,
Bora, you don't understand why this query from this court.
my lord,
This is a document prepared by you,
prepared.
right? And
Prepared.
therein you say English. What more is required? to be?
Even if I, my lord,
That we will see when we hear
because
the matter.
the dais
That
spoke-
we will see when we hear the matter, Mr. Burua.
that
For the purpose of interim
but the-
vacation, we are not satisfied.
But the question is, my lord, when there is an alternative efficacious remedy available, can this honorable
we-
court, my lord,
When you can make two statements in the same proceeding, we
Because-
can also.
because the reason is this interim order was passed on the basis of
Okay,
all the other interim orders, annexure 8,
Okay.
9, and 10.
okay,
Now, my lord, annexure 8, 9,
okay,
10, 10
Mr. Burua.
has
What
been
we do is,
relegated to
we
the appellate
will,
authority.
we will dispose of the entire writ petition. Come back at 2. We'll hear the entire, you get your objections also.
My lord,
We'll finish it up.
my lord. Obliged.
And be careful with that page 15. Because there is no statement that you are not prepared in.
I'll
And we will
satisfy.
go by 15 only.
I'll satisfy your lordship. I'll try to satisfy your lordship. All right.
Yes, Mr. Mannan, what are you waiting for?
Your lordship, my seniority in lay. Kindly pass over the matter.
What are you waiting for?
My lord,
Huh?
part heard matter that you have fixed.
Oh, Ankit Jori.
That.
Yes. Yes. No, for you. Yes.
My seniority in legs, your lordship.
Let's
My
just
lord,
matter again.
my lord, I have a prayer, my lord.
What?
My lord, I have a difficulty today after.
I know that.
2
We
p.m., my
also
lord.
have difficulty. We have picked up enough matters. These are not very urgent matters. Let's this matter after a week. on a date to be fixed by the registry.
Your lordship.
Deeply obliged, my lord.
Writ
We
petition
permitted you.
Filed in.
We permitted you.
is
I have
on
fixed up
25th.
enough matters for me. I have enough work for my second half. You can't wait. And for
Lordship,
these matters, we will not wait.
the writ petitions are fixed on 25th. Kindly fix on 25th.
It'll come. You make arrangements, it'll come. You made us read the whole brief yesterday, and today you say you're not there, and you made a prayer that it's extremely urgent. So this is the urgency.
If my senior is stuck, I will.
You can't do it. You, whenever it comes up, it will come up. We are not interested. Hearing to what is. Yeah. It's a demand. Yeah.
May please, your lordship.
Hmm.
So the last occasion, lordship wanted to know whether
You have your seat, Mr.
whether we have been following the same procedures.
As a norm.
Yes, as a norm. Now, the matter came up on Thursday. Friday, there was elections there because of the All India was closed. Saturday, there was a half, Sunday, and today is Monday. We have been able to take out pre-recruitment processes.
I'm not interested in how many recruitment process. I'm interested in a statement from your officers.
Yes.
A written statement that this is the norm we follow for all the selections that was held at that point of time.
Yes.
Where is that? That's what I required from you.
Statement will be in the form of an affidavit that I can file. But beyond that, what I'm trying to submit today is that we have been able to take out the advertisements, which would otherwise substantiate that, yes, this is how we have been conducting our examinations.
Yes.
May it please your lordship.
Hmm.
Lordship, on the last day, lordship had told them that since they had already submitted that since last 5 years, they have been following this particular system of appointment.
Hmm.
My humble submission would be, lordship, what I have challenged here is the fairness in the whole process. And it is the fact that they have not revealed to the candidates the system that they are going to follow.
Is it fatal? Is it fatal? If that is the norm they follow.
Lordship may kindly refer to the affidavit in opposition.
I have gone through it. You were not here on the last occasion. Gone through it. Now tell me, what is your case?
Lordship, I have appeared for the interview. I was not informed beforehand about the interview.
Show me the requirement. Show me the requirement. Where it is, where is the requirement? That you must be.
I agree to it.
Then it's the end of the matter.
At the same time,
If you agree to that proposition so easily, that is the end of the matter.
I agree to the fact that there is no such proposition, but at the same time, there is a system. The written as well as the interview, both should be aggregated. This has been spelled out by the Honorable Supreme Court in various judgments.
Show me where they have not aggregated.
They have aggregated, but they have.
Mr. Sharma.
Yes, sir.
The final select list is a combination of marks of all the components or only of the interview?
The Viva, he has not got the qualifying
No,
marks.
I'm not on that.
Yes.
Persons who have got the qualifying marks.
Of the total, yes.
Persons who have got the qualifying marks, total examination is 200.
Yes.
So the select list is only on the basis of Viva or written group discussion?
Composite.
Composite.
Composite, but at the same time, Lordship, the component of Viva Bose, here it has been mentioned that it is 50 out of 200. Viva Bose is 50.
And that too again, Mr. Counsel, 20 plus 30.
20 plus 30.
20
Here lies
is
the problem.
your educational, that is not Viva. So it comes to 30. 33 point something.
Totally 70. 70 out of that 50 plus 20.
20. So that 50
comes to
in the
25%.
context of 200 would be how much? 33 point something?
33 point. I am not, even I am accepting the fact that it is more than the.
So you accept that you need not be communicated. You accept that the mark, what is left?
But the unfairness lies in this particular fact that 50 marks have been allotted for a subjective assessment where the total 150 marks test that has already been taken that negates the whole 150 mark.
Still not. 150 is still there.
150 is
For
negates
these
because
projects,
in
if they see, I'll answer that. I got what you're trying. You're going to trying to take me to Ashok Sharma, basically, and that line of judgments. But here, see, this is not a case wherein it's an admission to a school or a college. It is a job wherein, in addition to knowledge of the subject, a practical approach is also required, which cannot be brought out by way of a written examination. So, interview. There are decisions of the Supreme Court. It says
1987, Rafiquddin.
Rafiquddin is on a different
It
context
speaks
altogether.
on that line.
It's on a different context altogether. It was that one selection candidates did not get the cutoff marks. They started making application. After 3 selection, they came in. So whether now that seniority will be from that day or prospective, that was the issue.
Rafiquddin also say in the particular paragraph regarding the distinction between an academical examination
That
and
you will find in subsequent judgments.
Yes.
So in that view of the
This is
matter,
not required. No.
My
you have not got a job anywhere till now.
My personality.
No, you have not got. Have you got a job somewhere?
I am not working.
You're not working.
I'm into business.
Oh, business. So if we give you a job, you're coming from today onwards.
As per the instructions that I have.
You are willing. That's good. Okay. We'll come back at 2. We'll hear. Get me those judgments.
Yes, sir.
Examinations are going to hell and they are not registering the students. So it is
That has to be considered in the light of the conduct of the petitioners.
petitioner's conduct is okay, my lord. That is to be considered by advocates failure, my lord, to appear in the time, my lord. Can the matter be taken up tomorrow?
25th. 25th.
My lord, can it be taken up tomorrow, my lord?
25th.
25th, my lord. That is that fixed, my lord.
25th.
My lord.
कोई नहीं बस by slip पठाई दिया है by slip पठाई दिया हाँ पठाई दिया नहीं पठाई ना हाँ ये तो by slip कोई दिया फाइल किधर है पठाई
Hello.
Yes. Yes, counsel. You can start. Mr. Sharma, you take your seat.
Lordship, like Lordship would kindly give me some time to delve into the.
You have the full evening for you. Go ahead.
Obliged, Lordship. Lordship, in the affidavit in opposition, they have mentioned that the components of the interview, viva voce as well as the other components have been mentioned. The written mark consists of 100 marks. The written exam consisted of 100 marks and the rest 100 comprised of 30 marks of GD and 70 marks of viva voce. Now GD group discussion.
Your good name?
M. Dasgupta. Group discussion. From group discussion, the personality as well as the interpersonal skills of the candidate can be assessed. The remaining component consists of the viva voce, which has again part A and part B. The part A is comprises of the marks obtained by the petitioner all throughout his career. Right from assessment of the marks he has obtained, educational qualification and such. The part B consists of 3 components, namely the professional knowledge and skills, which consisted of 40 marks, the personal attributes like appearance, manner, bearing, and the general proficiency, including proficiency in extracurricular activities. Now, my submission is that my candidature has been cancelled on the basis of this part B, particular part B of the interview by Babu. Here, altogether 50 marks has been allotted. Out of the 50, 40 marks has been allotted for professional knowledge and skills. Now, my submission is that I have already appeared for the written exam where I was assessed of my professional knowledge, including my domain knowledge. So I have already appeared in that and I have secured more than 70% mark in that. I have been disqualified in this particular section B of the Viva Voce, which comprised of this professional knowledge and skills. Now, particularly these can be assessed either through 1 question or 5 questions. Now, my whole candidature hinged on this particular section, which is 40%. Here, now this is where my whole candidature hinged. I could have secured 150 in the rest component, but I will still be disqualified if I do not secure even 25 out of that 40. So this particular assessment, this kind of assessment leaves enough ample scope for malafide.
Got it. That's your argument. Show me the law.
I have already given one citation of, submitted one citation of Himani Malhotra case.
Place it. Which
Where-
relevant paragraph?
In this particular,
Can you give me the citation?
the citation I have already submitted earlier. This particular case had referred to the Justice Shetty Commission, which had specifically mentioned that any Viva Voce test should be in.
Justice Shetty Commission is applicable here also in this proceedings. That will not be applicable.
That is
So
not
the ratio
applicable,
of
but I
Himani
am
will be.
referring to this particular citation where they have referred to the.
Can you just give me that citation? What is, no need. Give me that citation.
The Viva Voce test.
No. Give me that number, that SSC online, SSC number, SSC. 2000?
2008.
2008?
Read petition number 490 of 2007.
High Court of Delhi.
Supreme Court cases 2008 judgment. Decided on April 3, 2008.
Okay, paragraph.
Paragraph 17, last part.
Read.
The Viva Voce test, this court further notices that the Honorable Justice Shetty Commission has recommended in its report that the Viva Voce test should be in a thorough and scientific manner, and each should be take anything between 25 to 30 minutes for each candidate. What is recommended by the commission is that Viva Voce test shall carry 50 marks and there shall be no cutoff marks in the Viva Voce test. What I want to submit is that it has been mentioned that thorough and scientific manner should be followed while conducting the Viva Voce test. And in this particular case, when 50 marks is allotted, out of that 40 marks is allotted for only person for a subjective assessment, where the candidate's personality as well as professional knowledge is determined, which could be through 1 question or 5 questions. That is not scientific as per my proposal. Now, the respondents have claimed that they have been following this particular method since last many years. Even if they are following this system, this is as per the judgment that made available, this particular process is not without any flaws. Now, if the respondents feel that this is the system they have been following, and their statement is that they have followed this system, where they have cited earlier notification, where I'm not since it has not been handed over to me, but I believe that specifically the allotment of marks at the same time, the criteria for conducting the interview has not been specified in those earlier notifications. So they have remained silent in earlier cases also. Now, if they have followed the flawed procedure, can that be a precedent? And moreover, the respondent should at least, I would like your honor to, your lordship to kindly order them to give an order so that they file an affidavit stating specifically that they followed this particular system without revealing the specifications of the interview conducted at the same time. While conducting an interview for such special classes of candidates, like the reservoir engineers or production engineers or geologists, they have followed this particular criterion where assessment was similar. If they can state that they have been following this particular criterion, then it's up to your lordship to decide upon.
Anything more? Any further judgments?
I've already presented, submitted the Mohinder Sain Garg judgment.
No, you say already submitted.
Yeah.
I'm hearing the matter for the first time. I don't know where you have
When
submitted.
the matter
There is
came up
nothing
in
on
the
record.
other court last.
No, Asani, but
Still, I have a copy of that.
Mohinder Singh Gill, what do you want to say? Para
Talks
8.
about the 15% and 25% criteria.
Citation?
By vote.
Citation?
Criminal appeal number 5329 of 1990.
Can give me copies there. Para? Para? Dasgupta para?
Para A 33AB, 37 and 38.
Okay. Anything more?
Mohinder Singh Garg, I have the submit.
Oh,
the friend is relying upon.
Garg.
Garg.
And another
Regarding
is
the
Barod
fixation of
Vijay Kumar
Viva voce
Balakrishna.
marks.
Barod Vijay Kumar Balakrishna. 2007 Supreme Court cases 308, 2011.
2007 SCC 308.
308.
Para?
Para 38.
Body proposition?
Lordship, may I read? Now coming to the facts of the case in hand, though the rules framed under Article 309 of the Constitution governing the selection process mandated that there would be minimum qualifying marks each for the written test and the oral interview, the cutoff mark for Viva voce was not specified in the advertisement. In view of the omission, there were only two courses open, one to carry on with the selection process and to complete it without fixing any cutoff mark for the Viva voce, and to prepare the select list on the basis of the aggregate of marks obtained by the candidates in the written test and Viva voce. That would have been clearly wrong and in violation of the statutory rule governing the selection. The other course was to fix the cutoff mark for the Viva voce and to notify the candidates call for the interview about it.
Okay. Anything more?
This is, of course, that the commission followed. This was in compliance with the rules and it did not cause any prejudice to any of the candidates either. Thus, we see no illegality.
Got it. Anything more? This submission complete? Okay. Now you come to page 86.
Page 8.
86. Paragraph, internal page 13, paragraph 26 of the affidavit. Internal page 13 of the affidavit filed by the company.
Oil affidavit, page number 13.
So they have taken a stand there. Now your reply is at page 8 of your affidavit. Para 15. There.
Para 15.
Internal page 8. That is your reply? Right?
Yes.
So you also don't deny that process. You say if it is followed, it is wrong. Why have you not presented a challenge to that by amending the writ petition once this came to the forefront? Just wanted to know your thought process. May not be material, but your thought process. Why? Because this goes to the root of the matter. This is not under challenge in the writ. You were not knowing about it. Once you have known about it, that this is the procedure they have projected to follow, why was it not put to challenge? Why was an attempt not made to challenge that process?
I have come to know about this.
You
whole
came to know
process
about this on
after filing an RTI.
4/10/2013, and in your writ petition also, you have brought on record certain materials. There is an RTI application, right?
Yes.
And these matters were disclosed to you. Why did you not put it to challenge?
I have challenged the whole process that was followed. I have challenged the whole process that was followed through this writ petition. I was not sure whether the whole process involved any mala fide activity.
No,
on the
you
part
got
of-
it on RTI that this is the apportionment of marks made.
Yes.
Where have you challenged that part of the selection process? Your only challenge is a vague challenge to the writ petition. Fine. We'll read it along with paragraph
Paragraph 26
of
of the writ petition.
You have given a very detailed grounds. Paragraph 34. Right? Page 17.
Yeah.
Here, you refer to Ashok Kumar Sharma
Yeah.
and 12.5. Right? And thereafter, this cutoff thing, the only thing that I find is paragraph
29.
W, page 24W. Right? Now, have you made any allegation against the selection committee of being biased, mala fide?
I have
Because
directly.
Mr. Dasgupta, today I am on your instance, trying to interfere an appointment made 10 years back. So I'll have to be doubly sure. Have you brought on record the officers of the company who were involved, like your paragraph W, to appoint persons like Mr. Mannan, who was very close to them? Okay, fine.
I have not made any particular allegation against the
So,
committee.
if that yardstick was equally applied to all, and the subsequent judgments of the Supreme Court are there, so I'm sure Mr. Mannan and Mr. Sharma will place, that this 12.5 is not the benchmark. It can differ. So if that be so, what is the prejudice cost?
I have already made a submission regarding that, Lordship. That 12.5 or 33% might not be a big issue here.
But
the thing is that, the assessment was made only on particular question. That is the 40 marks allotted in the group B, where the cutoff mark was
Okay.
there.
Show me a statement from your writ petition to the extent that you were not even asked any material question. That it was just a farce. The whole interview was a farce. You went there, sat there for 5 minutes. They asked you about your family and you said, go. That you said scientific examination, that was not done. Is there any material on record to that extent?
I have
Okay.
not.
You will have to plead. An oral argument will not do. You'll have to plead that, right? You might have pleaded somewhere. Find that out. We'll hear Mr. Sharma in the meantime. You find that out for me. Yes.
Just to answer to this query of your lordships, to the contrary, he has otherwise said in paragraph 8 it is stated that the petitioner performed exceedingly well in the written test, group discussion, and interview. So there's
Exceedingly well to the
reply to the
extent of his questions you asked him. He says it was not scientific. That's why I asked him, Mr. Dasgupta, please have your seat. Find that question for me. Yes, you argue.
Yes. Essentially, this is a case where an unsuccessful candidate is before your lordship challenging the selection process on the ground that the procedure that was adopted, number one, not communicated to him. Number two, the marks allotted for Viva Voce is something that is beyond what the Supreme Court has said in Ashok Kumar Yadav. And number three would be a case where he has been wrongly non-suited. That 25% was the cutoff, and he got 22, and therefore he is not happy with that mark. So these are the three grounds. So now, number one, if I see his writ petition, the prayer in the writ petition is for setting aside the selection result. He does not refer anywhere to the selection procedure that was adopted. Paragraph,
That is why this pertinent question I put to him.
Yes.
That why have you not challenged that?
Yes. Page 27 would otherwise indicate the prayer. There's only one prayer. Page 27. His prayer is for
Selection
quashing
result.
the entire selection result. Now, selection result is the conclusion, is the outcome of a selection procedure. Here he is pleading a case where he is saying that he is not happy with the selection procedure because he was non-suited in that, because oil adopted something behind his back to take him out of the process. But then his prayer would indicate it was not challenged, number one. Number two, as your lordship has rightly pointed out, in 2013, we have filed our affidavit. In our affidavit, we have categorically stated the selection committee constitution as well as the guideline that was applied. That is, lordship will find that page.
We have got it.
Yes. Page 90 is the constitution of the selection committee. Though in the RTI, he had come to know about the apportionment of marks. Plus, in our affidavit, we have disclosed everything. We have stated how the constitution of the committee was made of 5 members, followed by the guidelines in Annexure A. Now, this entire guideline was before him. He did not took that effort of filing an application or, for that matter, amending his petition or challenging this particular guideline. As we have stated, this is the guideline uniformly been followed in Oil India Limited till 2016. The documents that I have furnished before lordship, there's another document there wherein the change of policy of Oil India Limited is there by way of a notification of 2016, wherein lordship will find the statement there in which have stated that the policy that we were applying all along was this, but now because of Supreme Court judgments, we are changing our policy. If your lordship will just come to that. Those documents that I have handed regarding the advertisement, the last 6th of January 2016 circular. Not a very legible copy. I apologize for that.
6th of January
2016. There are 3 advertisements. And thereafter is there
January
2016.
7th of January.
Yes, I think so. Yeah, that's inside page 7th of January. Now, if your lordship will come to the internal page number 3, para 5. May I just read? As per the current policy of recruitment, below grade D selection process comprised of written test, group discussion, and Viva Voce as under. Lordship will see the marks. Written test 50%, or weightage is 50%, group discussion 15, qualification 10, interview 25. Now,
You
this
read
has been
5.1.
Lordship?
You
Yes.
read 5.1.
5.1, yes. The Honorable Supreme Court in Mahendra Singh Garg versus State of Punjab and held that there should not be more than 15% of marks in interview in selection of candidates fresh from college and schools for public employment by direct recruitment, where the rules provides for a composite process of selection, namely written examination, interview. Further, the Supreme Court in Muninder Kumar versus and others, etc., versus Rajiv Govil, held that the allocation of marks for interview and group discussion should not exceed 10%, 5% respectively. The selection process involves a group discussion also. Accordingly, it is
So,
proposed.
Mr. Sharma,
Yes, Lord.
you accept that the process that you were following is wrong.
2016.
Be that as it
No, what we say is,
be that as it may. But that is contrary to the Supreme Court judgment.
What we say
That is what the petitioner is trying to argue.
yes, yes.
So, if a process is otherwise contrary to the Supreme Court judgment, your mere acceptance of that will not change the law.
Yes.
So,
No, my case otherwise would be the Supreme Court judgment has been later on diluted in various judgments whereby it has said,
why are you taking me into this?
no, just to
You show me those.
just to indicate that we have
If this
followed
is the law, you do it in 2016, I'll deem it that it should be there from the day 1990.
I know this is a double-edged sword, but my endeavor was to indicate the process that was followed
No.
in 2010.
No, this change is not for a decision that came in just proximate to 2016. These decisions are there from 1990.
I understand.
And the selection process in question,
Lordship may not
Is
take judicial
covered.
notice of this document. But
if you are pressing on this,
no, I'm not pressing.
I have my own.
I'm not pressing. Just for that
You
reference.
show me that prescription of marks of 12.5, 33%, Supreme Court has said varies. Place those
Yes, yes,
judgments.
yes, yes. Lordship has already had Ashok Kumar Yadav. Now, Ashok Kumar Yadav itself says Ashok Kumar Yadav is followed by Mohinder Singh Garg, and then just two judgments I will place that beyond what has been placed by my learned friend. One is Muninder Kumar, 1991.
Mr. Sharma,
Yes, Lordship.
that is not going to help you. There are others.
Jasvinder Singh,
Citation,
citation is 2003 to SCC 132. And there is another called Liladhar.
from Lidaldhar onwards,
Liladhar also,
onwards you see.
yes. Liladhar, I have that Liladhar one. Liladhar also says that it cannot be as a thumb rule,
Fixed rule.
fixed rule, as a thumb rule. He uses
That is
the
why
exception-
I was asking you whether this is the norm. Liladhar and all other cases, there is a rule or a laid down procedure which says that this would be the. So you being a company, you may not have a rule, but if you have a policy decision to that
Yes.
effect, then that stands protected.
Yes, the policy decision was to follow this, the Annex
Otherwise,
A.
the petitioner is entitled to a direction. If you can't take the case out of that position,
That's true.
where Mr. Dasgupta has taken it,
My entire endeavor would be to say the Supreme
he
Court
has
will
2
finally-
points valid. One, and we can ignore those technicalities in the prayer. Amarit could. I can ignore those technicalities. One, how could you have prescribed marks for Viva in excess? Two, why did you not communicate the
Allocation
cutoff
of
marks? Cutoff marks.
Cutoff marks.
Now, the cutoff marks, for that you can take resort to the plea in those judgments which says that, okay, fine, if you have it, then that will apply.
And uniformly been followed.
Followed, then that will apply. Get those judgments on record. One, with regard to prescription of marks, Lidadhar and onwards, Ashok Kumar Yadav 12.5 has been slightly diluted. You can't have a big variation, but there is a dilution. If those judgments are not there, I'll have to interfere.
Judgments are there.
Where? If you don't have it, bring it tomorrow. No
Tomorrow,
problem.
tomorrow.
Yes, Mr. Manan, what is your?
Wait, please. My case, your lordship, basically, he doesn't have any allegations, direct allegations against me. Because he has just said.
You might be a victim
Yes,
if
only thing
we
is-
hold that the arguments as advanced by Mr. Dasgupta is acceptable. You might be a victim. That's why he has made you a
Yes,
party.
that is the reason. There is no allegation. Now there is no allegation that I am not eligible. There's no allegation that they have given me the particular appointment was made on the basis of
What
some
do you say
malafide
about
or
his
something.
arguments?
Huh?
What do you say about his arguments with regard to the manner of the selection?
The manner of the selection, your lordship, there are, I'll give a judgment, very recent judgment, in fact, 2023 judgment that I got it in the lunchtime today.
Justice MR,
I was
Justice,
referring to around
Justice
10.
MR Shah.
Huh?
MR Shah's judgment.
No,
Justice.
this is a judgment of, I'm handing over. Ek on yours. This is a Tasveer Singh Sodhi versus State of Jammu and Kashmir. Here, your lordship, I am giving this live log because I got it here. I actually got a few judgments, which most of them are referred in this. Everything, your lordship, in this judgment. So I'll come to the judgment. Your
KM Joseph.
This is
This is there in
KM
SSC
Joseph
online.
Nagarat. So this judgment, your lordship, I'll not go into many paragraphs. Paragraph 7.1, 7.2, 7.8, 7.10, 9.4, 14.2, 14.3, 16 and 16.1. Now 16 and 16.1 is very important because here, your lordship, that Rajasthan case has been discussed of Leeladhar have been discussed where the whole paragraph has been quoted by this one. My case, your lordship, basically is that it also happens to be here that even if there is something wrong in the selection, I may not be affected because there's no allegations against me. There are also judgments given in this particular judgment. Very few judgments have been shown where it has stated that not the whole process should go. The persons who are selected, they cannot be, your lordship, affected. That is also there. That is also there. Here, I'm not reading the facts. Facts are very long. So if your lordship will start from page 11 of that judgment for a moment. These are all judgments here, your lordship. That is why I'm just trying to point out. I'm not giving so many judgments. Just these are all quoted small in small paragraphs. So if your lordship will take up this page 11, which is at the bottom, your lordship will see the page numbers.
No, I've got it.
Yeah, that reliance was placed, first paragraph, on Reserve Bank of India versus CL2 RAT, 2004 4 SCC 657. To contend that there where no procedure is prescribed for a selection committee.
That is the change.
That is
the change.
Yes, that is in 2004 year. Now, the second one, your lordship will kindly see. Next, 7.2. It was further submitted that it is a settled position of law that when a selection committee recommends the selection of a person, the same cannot be presumed to have been done in an erroneous or mechanical manner in absence of any allegations of favoritism or biasness. That is what I'm arguing here. That is, a presumption arises as regard the correctness of the decision of a selection committee, and the party who makes the allegations of bias or favoritism is required to prove the same. Thus, in the absence of malafide against the member selection by a selection committee cannot be doubted. To buttress this argument, learned counsel placed the following judgments. These are the judgments on that particular point. This is one point which I am trying to point out, that there was no allegations against me.
That's what I was asking.
So why should I be affected? Now that is decided at 7.8. Learned counsel Sri so-and-so submitted that in the absence of a large-scale systematic irregularity that denudes the legitimacy of the selection exercise, the entire selection cannot be set aside. This court in so-and-so has held that those who are innocent of wrongdoing should not pay the price for those who are actually found to be involved in irregularities, and
By
therefore
relying on this, Mr. Manan, you're trying to impress
my part.
your part.
Yes,
And so
my-
whatever happens,
I cannot
this court should not go and undo
undo
your
what
appointment.
14
10 years
years back, where my appointment. This is basically, my line is that because they were the councils or the Oil India was supposed to argue on the point of the selection, though I have come up. Here also, they have stated a few points. With
You are
regard to-
basically on the prayer that the result should not be touched.
Yes, that is one part. Then, your lordship, there are so many other judgments. All are record. In fact, court should not sit in appeal. Court should not go into all these things. That is also there.
Timmaya and all
The
are
last
still-
part which I tried to point out, that your lordship also pointed out, it is your lordship shown in the paragraph. 14.2, at 22 page.
Mohinder Singh.
Mahinder Singh Garg.
Same thing.
Same thing.
It goes to the extent of saying that
Yes.
without the selection committee members being questioned, the selection
Yes.
process.
That he has not done.
That is,
And
but
Rajesh
we have not reached that stage. We
And-
are still in the selection.
And then your lordship, the last paragraph, 16, at page 26.
Leeladhar.
Leeladhar is 16.1. I'm reading 16. The court has upheld the legitimacy of conducting interviews as a part of selection process, even when marks are earmarked for the same has been found to be prima facie excessive. And then Leeladhar comes, your lordship, made the following pertinent observation as to the importance of the viva voice or interview in a selection process, quoting that. In fact, I have quoted this in my affidavit in opinion. This is basically on the basis of this fact. I think this writ petition cannot survive. Two things.
But for that,
And there is a delay.
for that,
And there is a delay
that-
coming before this.
for that, he has explained that. That delay is explained because he was waiting for the materials.
Okay.
He had put in appeals.
Mhm.
RTI went up for an appeal. Then he got the details. So on delay, we will not suit it. Now, only thing I am waiting for is for the
My learned friend.
ONGC to satisfy me that 50%
I could
and
have
cut off.
got those judgments, but since I was on my case,
You're true. Yes.
this case suffice to my argument. That is what I'm trying.
No, this will come once we have crossed the stage of selection. This is consequence.
The consequences, your lordship, whatever consequences.
Consequences we will protect.
Yes,
If we
that is
find
what-
that he is there, we will ask them to
And-
make a post for him.
Actually, this is my case because I am the private respondent.
We may not be today inclined to interfere with your.
Yes.
But if they find that the petitioner is liable for an appointment, we will direct them, create a supernumerary.
Because that will not affect me.
That will not
will
affect
not
you.
affect
Not only you, any candidate.
And no, the other 4 candidates or 3
Are not
candidates have
here.
already retired. Oh, sorry, resigned.
Resign.
Resigned.
You are the only one.
I am the only one. I am there for the last 14 years. Now I am a deputy general manager.
Will not.
Whatever it
Don't
is,
worry.
this
This court at least, I don't know what will happen in appeal, but this court will not touch.
Yes, that's basically
But
my
we
case.
are concerned with the
Rest-
rights of the petitioner.
Rest, your lordship, these judgments my learned friend is supposed to submit with regard to the part wherein 12.5%.
Yes, Mr.
That I
Sharma.
can also produce tomorrow if your lordship. Or he might produce it now.
I want it from the appropriate authority.
That is what I was not.
You have done your
bringing
part.
those judgments.
You have done your part.
I thought Mr. Sharma will bring those. So I was-
Leeladhar, I am not having that Leeladhar judgment, but Leeladhar is.
You don't
quoted
have
other-
any of those judgments which is required, and we will follow what you have submitted. That change in policy. We'll follow that.
That is the subsequent decision taken. That is something else.
That is a decision which recognizes that you were doing a mistake. And that is exactly what the petitioner is trying to canvass. So
Therefore,
when? Tomorrow, day after?
Tomorrow.
Kali. Mr. Try to find out something more. Even if we give you, we will not touch the others.
Lordship, under the changed circumstances, I believe what he has submitted, Mr. Mannan has submitted, that is true. That they have already been confirmed 1 year.
Will not touch, will not touch them. But only question is, if you are to come in, we will find a way out for you.
But then there will be other candidates also who took part in the selection process.
That
who may have marks above-
you suffer.
who may
you
have
suffer.
marks above him.
For that you suffer. We have nothing to do. We are only concerned with him.
I'll try to satisfy Lordship on that aspect that this can be diluted. That Supreme Courts have said this can be, it's not a thumb rule.
And if you
I'll
stick
play
to
this-
your this,
I'll have
gone.
to.
I'm not giving it back. You have given to me, it will be with me.
I'm not filed it by way of an affidavit, so I can have it.
Tomorrow, be here tomorrow. Tomorrow, 2 p.m.
2 p.m.
By sleep. I'll tell you, I'll 2 p.m.
Like,
list this matter again. Yes. What is your instruction?
Lordship, some instruction has been received, but today Mr. R.K.D. Chaudhary is not there. Let the matter come up day after tomorrow, Lord.
Day after tomorrow.
Yes.
It will by slip for you. Day after tomorrow. On the prayer of Mr. R.K.D. Chaudhary, list this matter again on Wednesday.
My lord, this matter may be kindly listed after 7.
We have heard
Instruction has
Mr.
been received,
Rabha.
Lordship. Yes, we have.
We have heard Mr. Rabha. We just want a clarification. That's all.
Kindly opt.
Follow. Saros. 25 what was it? So Chalia, yours is 25. 25%. Yes.
My lord,
Only thing we find is that the petitioner did not disclose complete particulars.
I will, to that order, my lord, I will take your lordships to page 59 of the affidavit in opposition submitted by the respondents.
Page
59. It is a letter from the principal to me.
affidavit in opposition in the WPC.
In the affidavit in opposition submitted on behalf of the respondent number 5 here.
Okay. Yes. Page
Page 59.
Ah.
It is a letter addressed to me. to the
dated,
petitioner,
dated.
Dated 18/11/22.
Okay.
Here it is stated that I am asked to work from 4/10/22 till for 11 months till 3/9/23.
Okay. And then
During that period, Milan,
if you just proceed further, come to page 70 of that
No,
same affidavit.
let me tell Milan. Because during that period, although I was not there, principal asked me to attend to the classes of the students, Milan, since there was no Boro teacher in the college. And in the interest of the students, I had to work there.
Okay, fine.
On-
This is
only for that
1811.
reason, I had stated, Milan, I have been working.
No, 1811, we have no doubt you are working. You come to page 70. This is 31/12/22. Right? You resigned. Page 70. Continuation.
Oh, yes. 65 Milan.
Huh?
65. right?
69. 69 originally is at page 70.
Or maybe.
He has resigned on this letter on 31/12.
31/12. That was the date of interview. On that day, I resigned from the
Okay.
college.
Now you come to the next page, 71. If you were working in the college, what required you to get this?
No, I said, Milan, I came out from the college, but in the interest of the students,
That is different thing. How can you on that basis claim regularization? You have not disclosed that in the writ petition. Mr. Chalia now is trying to protect, I know, that is the beauty. But your client did not disclose this even to you.
that is true, Milan. That is true.
That I can understand by your appearance. I know that. If it was there, you would have covered it.
Yes.
You would have covered it up.
Here, Milan, only because of that, Milan, I said that we will do this petition without any hassle.
Okay. Mr. Chalia is appearing no cost. But he played a fraud with you. He should have disclosed this. You would have covered it up.
That is true, Milan. That is true.
Anyway.
And I am sorry for that.
No, not. Not Mr. P.D. Cholia, Learned Counsel for the petitioner. P.P. Cholia, Learned Counsel for the petitioner. Learned Senior Counsel for the petitioner, assisted by Mr.
I, Ahmed.
I,
Ahmed.
Ahmed, Learned Counsel for the petitioner. P.P. Cholia, Senior Counsel, assisted by Mr. P.P. Cholia. P.H.A.L.A.I.A. Assisted by Mr. I,
Ahmed. Ahmed.
Learned Counsel.
Ahmed.
Hamid.
Ahmed.
Ahmed or Hamid?
Ahmed.
Ahmed. Ahmed,
Wait.
Learned Counsel for the petitioner. Mr. Learned Senior Counsel submits on instructions that the petition does not desire to press this matter any further. So accordingly, the writ petition stands dismissed for non-prosecution, dismissed on withdrawal. Full stop. Huh? IAC 388-877-23. In view of the orders passed today in the WPC number 6045-2023, no further orders is called for in the present interlocutory application. Accordingly, the same stands closed. Oh, interim orders, if any, stands vacated. Yes. What is the instruction?
Your lordship, already, your lordship, matter has already, I would like to take you to the page, your lordship, page 39.
I gave you time to
Yes,
read.
My lord.
Yes. Now, what did you get?
My lord, my writ petition, my lord, para 2, my lord, I have mentioned that my petitioner is a social worker, my lord, and earlier she is a retired headmaster. No.
No, I wanted on this,
She is
that
not-
this is a wrong statement.
No, my lord,
That third paragraph that you contested an AP member.
my lord, she is not a political leader, my lord. No,
He contested election.
no, my lord,
Sure,
my lord.
we take it.
My lord, instruction may be given, my lord.
Huh?
Instruction may be given, my lord.
Who will take instruction? You will have to give me. You will have to
As
tell
per
me.
my instruction, my lord, she is not
Sure.
here, my lord. Your lordship, I would like to take you to page 39, your lordship, of the writ petition. Subject, your lordship. Prayer for removal of Qazi Fatima Begum Chaudhary, your lordship. From the SMDC president of AK Azad High School in the district of Karimganj because of her unlawful activities and various corruption, your lordship. Your lordship, I would like to read your lordship.
We have read it, don't it?
Yes, your lordship. Your lordship, on the last line, your lordship, we therefore request your kind honor to remove the said uncultured, drunkard and shameless SMDC president in the interest of this ancient
Those
kind.
are exaggerations. Those are exaggerations. You get my point? That is of no use. Third paragraph is something
Yes,
which she says is not there.
she is, yes, your lordship.
So what do you want us to do?
I don't.
You are already out. What right now you have? What right of yours is violated?
My lord, at this stage, notice may be written.
No notice. You argue. We will finish it. You show me your legal way to get back that post.
My lord, that representation.
This is a nomination honorary thing.
My lord,
Will principles of natural justice apply here?
my lord.
Will it apply? Work on it day after tomorrow or Thursday.
My lord, next week, my lord.
No, Thursday. You work on it. Study. Read. Come and satisfy me whether in a case like this, pleasure appointment, whether the principles of natural justice will apply. Right? On the prayer of the parties, list this matter again on 25.
Only my presence may be recorded.
25/4/2024. Ms. P. Das, Learned Counsel, Learned Standing Counsel, Secondary Education is present. Full stop. The Learned Counsel for the parties shall address this court with regard to the maintainability of the present proceedings. You do it. If she does not do, I'll pass orders in your favor.
Deeply obliged.
Ms. Das, if you don't bring on record materials, law point, I'll pass orders. Yes, Mr. Prakash.
I'm sorry, my lord, I was not.
2005.
Yes, lordship.
Show me the law that after 19 years also, this I should give you.
This aspect, my lord, in the earlier round of litigation, my lord, this noble court has issued the direction.
I'm Liz Borden. Now that is finished chapter. This is a new chapter. And within that period, Devabroto Tiwari has come. I'm bound.
My lord, another judgment, my lord, of the Supreme Court, my lord, may I
Which year?
of 2022, my lord.
I'm having
order
23.
dated-
I'm relying on 23.
Order dated 20th.
What is the name?
Name হলো মলয়ানন্দ শেট্টি মলয়ানন্দ শেট্টি versus State of Odisha.
Devabroto Tiwari kitna tha re? Citation? Okay, that case wherein false appointment also. And you got it in your house, you did not know. That's the case. You got an appointment somewhere,
Yes.
fake appointment.
Fake appointment, and FIR also fine.
Not-
FIR, there is no FIR, man.
No, forget it. You got a fake appointment in your house. Why don't we get that? Why that fake appointment went to your house specifically?
God knows.
Huh? And God only knows, and you know. And the person who has sent you, he knows.
God.
There are many people in the state. Nobody receives such appointment orders. How come you received? And tell me, how did you with that go and join without confirming?
It is also surprise to me also.
Heard Mr. P. Purkhaisto, Learned Counsel for the petitioner, also had Ms. D. Das Burman for additional senior government advocate
For respond number 2 and 5.
for respond number 2 and 3.
5.
2 and 5. Also heard Mr. P. Talukdar, Learned Standing Counsel, Elementary Education Department.
1, 3 and
Respond number 3 and 4. 1, 3 and 4. Devabroto Tiwari dismissed. Sorry.
But I'm sorry, Lordship, at that time, and guess in another court. But this matter has already been heard by your Lordship several times. Today is supposed to pass
Orders.
My lord, earlier round of litigation, Lordship, the matter was remanded if the petitioner.
Your case is that they say that on the time of initial appointment, you did not have the qualification, which is contrary to section
4.
6, 1 and 2 of the 6, 1 and 2, you see.
Yes.
Right?
Seven also, section.
7 also.
My lord.
Right. 7 also. 7, section 7 also. 7, 1 or 2. 2, I suppose, no? 7, 1,
1 and 2 also.
1 and
Basically 1.
both the cases, Mr. Khan, you are appearing,
My lord.
but you will not get the order before Monday.
Okay.
Dismiss. Disposed of. We will remand back the matter.
My lord. Obliged.
Yes.
Yeah, please, your Lordship.
Hmm.
Lordship, petitioners are appointed as third post of assistant teacher in Lower Primary School, Lordship, during the period of 2000 and 2011, Lordship. And
So, the only thing that is required to be looked into here under the 2017 Act is whether under RTE, the students were there.
pupils and students ratio, Lordship, all the schools have more than 100 students, Lordship.
That's a vague
RTE,
statement. There are many schools here. That's a vague statement.
Lordship.
You have not brought in specific material. File an additional affidavit. Otherwise, how can we? And the authorities have also not, in their reports that are there, page 66 onwards, not dealt with this issue. Only criteria is how many students are there.
Lordship.
I think 80 is required for the third post. 80.
90,
Huh?
105.
Total 105.
Lordship, for third teacher, Lordship, 91 to more than 91. Ratio is 30 is 1. Primary school, Lordship. 30 is to 1 is the ratio, Lordship.
So we don't have the data. As you have, I think here, how many schools? Many schools.
Not lordship here, 7 petitioners are.
7 petitioners, 7 schools.
And 7 schools and.
So we'll have to have only thing you tell us is we have more than 100.
Lordship, we have annexed class wise enrollment lordship.
Where?
Annexed are 2 lordship starting from case number 43,
43.
starting from page number 43.
Yes, madam.
43, 44. Here is lordship, total enrollment is 125 lordship.
Of which year? 23. Which year? 22, 23. That will not do.
23 lordship.
That will not do. It has to be proximate to that time.
Lordship,
Yes.
the seal is 22, 23. Seal of the headmaster lordship.
I know, but this is subsequent. We want on the date of provincialization, that act came into being. What was the strength? Your schools were provincialized under 2011 Act.
11 act lordship.
Yes. What is your instruction?
But as per 3-1-10, my lord, additional post cannot be, my lord.
3-1?
3-1-10, my lord.
Read.
The 2 members of teacher and or tutor of the Ventura LP school shall be provincialized under this act, and their services shall be merged with the base school identified in respect of the area wherein the said Ventura.
This is not this is not an LP school. This is ME school.
This is LP school. my lord.
LP school.
LP school.
LP school.
I get the impression that it is a ME school. Okay. Page?
Page 111, my lord. 111.
Hmm.
10, my lord, 2 numbers of teacher or tutor.
Okay, madam. After the merger, there is a shortfall. How can you show?
Lordship, the petitioners have challenged say 11 act lordship, which is declared as ultra virus lordship. In page number 16 lordship, when declaring the 11 act lordship as ultra virus, there is some observation lordship.
But that you have already got the answer from the division bench.
Lordship.
Division bench said nothing doing.
But
You're not entitled to a salary.
division bench have salary lordship.
You're not entitled to salary. Division bench said.
Salary is not entitled, but lordship, in division bench judgment lordship in page number 61 lordship.
62.
61 lordship, paragraph number 3, paragraph number 2 lordship, having taken note of this 61.
That you
lordship,
forget. Come to the next paragraph. At the outset.
at the outset, what is necessary to be taken is that the appellants will have to establish their claim for provincialization of their services if the institution wherein they claim to work have been provincialized. In this regard, the decision by competent authority is to be taken with regard to the provincialization of the institution under the Act of 17. And in the said process, the number of the teachers staff to be provincialized as per the provisions as contained therein.
This is item number
Item
34,
number
35.
37.
37.
That's it.
Heard the parties at length. List this matter again on 2/5/2024 for delivery of orders.
25. Obliged.
Yes, Mr. Bukhester.
But in this case, the petitioner is having qualifications, etc., my lord, but.
Okay, you have everything. Come to page 34. Abdur Razak.
Yes.
So 4/8/2016. Right? Graduate scale.
Yes.
So if it is 4/8/2016, 17 years would be when?
Yes, sir. That I'm submitting, my lord.
First submit that. Then
He is not having the
you
experience.
are not eligible under that.
Yes.
Okay,
he
then
is
what happened?
Not having the, my lord.
Then what happened?
Qualification. Other, he is having the qualification, not the experience as graduate.
And you have
teacher.
relied upon WPC 5914/2022, Shantanu Kumar Das.
That is, there, my lord.
That has been dismissed by this court the other day. I'm not sure whether the order has been uploaded, but it has been dismissed.
There is no teacher. What division bench and judgment.
That is why the inspector.
The inspector, my lord, my submission is that the rule does not also permit the inspector, my lord.
It's not a rule permitting, it's a convenience thing.
Convenience, my lord. In that circumstances, my lord, division bench in 2012, 1 GLT, my lord, 728. In that judgment made an observation. It's not the direction, but it's advisory, my lord. Where it is stated, my lord, however, it is advisable that the department works out appropriate mechanism to deal with such situations where there is no candidate with the qualification of, it is regard to qualification, B.Ed or BT or candidates available juniors, so that the schools do not suffer. Such a mechanism may be worked out and notified within 3 months from today. But that has not been done. No such alternative mechanism.
We will ask them. We'll ask them to transfer somebody from a nearby school to your school. Qualified person.
That I have no problem.
No problem.
No
We'll do that. Anything more?
4 minutes.
We are upholding the speaking order.
My lord, but make
What
an
more can I do?
make an alternative.
We'll make an observation that the Director of Secondary Education is at liberty to transfer any other person having the qualification to man your school.
The qualifications I have.
No. Qualification means everything. Jagannath Pegu.
Experience.
Want to develop some other line? Want to? Heard the parties at length. List this matter again on 25/4/2024 for delivery of orders. You work out 10 minutes before that. Work out a line for me. I'll try. I'll be interested. No. Yes, Mr. Gupta. The petitioners have agreed with your the 7/2/22. They have it. He has a copy.
Yes. They only have submitted it.
Oh, last date. Their only plea is person at serial number 21 or anybody from your military should not be there. Serial number 21 or anybody from the military should not be there.
And should be close to Northeast.
But that we are not going to do. That
To
Tell me.
that, my lord, I may have some objection because, my lord, these persons are selected pursuant to a guideline.
No, I'm not on that. Serial
Serial
number
number
1
21,
to
yes.
serial number 20, you appoint anybody you want to.
Not 21. Then
Only problem is with 21 and a military person. Leave that. There is only, I find that 1, 2, 3 military persons, 4, 5.
my lord, here, my lord,
Whom do you want to appoint from here?
not here, these persons were appointed, my lord, they were appointed pursuant to the guidelines by the MOD. Now, my lord, removing them, my lord, amount.
Who is asking you to remove?
My lord,
Who has asked you to remove?
but 21 is already appointed, my lord.
They have some objection with 21. Can't you make a alternative arrangement and get the matter going? It's not that it's only 21 who is there. There are others also. Make it. Just leave that MES part and the 21 and do it and get along with it. We'll close the review petition.
My lord. My lord can fix it tomorrow, my lord. I will.
Tomorrow, fine.
Tomorrow.
Tomorrow morning.
Probably, my lord, the learned,
Huh?
learned senior may not.
Need not be. He has made his submissions. You be here. Edu kali logai diu. Dibo nalage file to your tweet level.
I will suggest
huh?
for child number 20.
21.
21.
21, they don't
Except
want.
21.
Apart from that, anyone.
Anyone. And your MES people should not.
I'll get.
Get anybody in. We will close it.
Highly
Next.
object.
Yes, Mr. Islam.
My lord, in this case, my lord,
Have you seen it?
my lord, I have seen my lord. My lord, your lordship, my kind, my
And
lord,
this is
say-
content.
One.
This is content.
my lord,
My jurisdiction is limited. There has to be willful and deliberate violation.
my lord, in first order, my lord, in my lord,
Forget it. Forget it. They have done something.
my lord.
How can I punish them now? Can I punish them? Make a challenge to this. The present contempt application has been instituted, alleging violation of the directions as passed by this court-wide order dated 18/1/2022 in WPC number 273 of 2022. More particularly, paragraph 6 thereof. Full stop. The directions as passed in paragraph 6 being relevant, it is extracted here in A to A, huh? Page 11. Right? Full stop. The respondents, counsel for the respondent has produced before this court orders dated 26/8/2022, issued by the Director, Elementary Education Officer, rejecting the case of the petitioner for the grounds stated therein. Also, the same was thereafter followed by a communication dated 13/10/2023, by which it was informed as to why the case of the petitioner was required to be so rejected. Also, subsequently, on 12/3/2024, a further order was passed by the Director, Elementary Education, and therein it was contended that the case of the petitioner was not in a position to be taken up for provincialization in as much as the enrollment status of the school, students in the school does not permit such a move. Full stop. The order dated 12/3/2024 cancels the earlier order dated 26/8/2022. Full stop. In view of the above, a perusal and on perusal of the contents of the order dated 12/3/2024, this court is of the view that a deliberate and willful violation of the directions of this court as passed by the above noted order is not present. Full stop. However, the respondent authorities having considered the matter and passed the said order dated 12/3/2024, this contempt petition would not be liable for any further consideration. Accordingly, the contempt petition stands closed. However, considering the issue involved, a liberty is reserved to the petitioner to present a challenge to the order dated 12/3/2024 by way of filing an appropriate application. You take your ground on that, we will consider. That will give me a more flexibility. Bring it next week. It's a Friday only, you bring it. We'll consider.
Okay. Since your lordship had indicated that your lordship would be taking the entire matter, therefore, my lord, I'm not pressing the I. I directly address your lordship on the core issue.
Yes, you go to the core issue. Forget the I.
My lord.
Who is the petitioner?
He is the.
Let him start off.
Let him know. Reply.
Yes, what is your case? Be here, no problem. Be here. What is your case?
My lord, on page 15, my lord.
15.
That is the, my lord, that is the, my lord, performer. In fact, my lord, just my lord, very, my lord, briefly, may I explain the, my lord, that on what consequences this, my lord, part.
You just show me. Forget the consequences.
My lord,
That way, I'll tell you. You go
On
ahead.
15, my lord, page 15, my lord, Renu Burman. Here, the, my lord, respondent number 6 is the administrator.
She has projected herself to be the English teacher.
English, my lord.
And
English.
you as the
As my lord, social science.
social study.
Social
Then what happened?
And my lord, there is some other, my lord, Nirupama Teka Hujuri. Nirupama Teka Hujuri, my lord, on serial number 2, my lord. She is my lord, Hindi teacher. Hindi. Now, my lord, that the Hindi and English, Renu Burman and Nirupama Deka has been, my lord, the service of the, my lord, Nirupama Deka and my lord Hujuri has been, my lord, provincialized. Only two, my lord, the service of two persons has been, two teachers has been provincialized.
Who have been provincialized?
My lord, Renu Burman on chain number 1, my lord, respondent number 6, and my lord, Nirupama Deka Hujuri. She is, my lord, chain number 2, she is Hindi, my lord.
So 2 language teachers have been provincialized.
Provincialized.
You have not been provincialized, and Utpal Sharma has also not been provincialized.
Not been provincialized. He is, my lord, he fulfills the, my lord, requisite criteria for, my lord, maths and science teacher, and as part of performa also, my lord, he is the, my lord, science teacher, my lord. He is a BSc. And, my lord, the qualification acquiring, my lord, by the Renu Burman, my lord, respondent number 6 is MA, and, my lord, the Nirupama Hujuri is, my lord, Hindi. So, my lord, if, my lord, it is assumed, or if she is claiming that he is a mathematics teacher, my lord, definitely the requisite qualification should be BSc, my lord. But here my lord, belongs from arts category, MA, my lord. It does not fulfill the requisite criteria.
Where is the minutes of the DLC?
Minutes of DLC is not there, my lord.
SLC?
SLC is not there.
So we have got nothing on record to show other than page 15 as to in what manner the cases of the teachers were processed and against which post. Nothing is on record.
My lord, that the particular is there.
Particular page 15 only.
Page
Post that there is nothing.
My lord.
Post that there is nothing.
My lord, that the selection, my lord, my lord, the list of my lord, selection teacher is there. Selected teachers, the list of provincialized teachers is there.
That is 3 names are given, but their posts are not mentioned there. Subjects are not
Posts
mentioned.
are not mentioned. But, my lord, the petitioner, my lord, the respondent number 6 has been, my lord, appointed as a tutor, not as a science teacher.
Forget it. Tutor science is also there.
My lord.
Tutor science is also there.
My lord.
Show me from the records that she was appointed as
tutor, man.
Tutor what? Science?
No, my lord. Only, my lord, tutor is there.
No, fine. Tutor is there.
My lord.
But show me materials.
My lord, if my lord, teacher is appointed as a my lord, tutor science, in the appointment letter it has been, my lord, written as, my lord, tutor and, my lord,
science.
But, my lord, in rest of the post, my lord,
she cannot be appointed as a tutor science because she is a arts graduate.
My lord, that is, my lord, the prima facie.
But she can teach mathematics. That's a different thing.
Different thing. And, my lord, another significant point is, my lord, there is no any specific, my lord, post for mathematics. There is, my lord,
science and mathematics.
Science and mathematics. And, my lord, just
she cannot be science and mathematics.
Science and mathematics.
Okay. Yes, Mr. Bula.
My lord.
You are an MA.
My lord.
You can't be science and mathematics.
I'm not science and mathematics, my lord.
There is no post of mathematics.
May I just to put things in perspective, my lord. May I just draw your lordship's
Show me
attention to the
DLC.
prayers.
Show me. Even after you submitted yourself as an English teacher, that the authorities considered you as a maths teacher.
I have taken my instructions. There was some inadvertent error in that page 15, which was further rectified, and that rectification your lordship will find, my lord, at page number 52
of the writ petition
of the affidavit in opposition filed by me.
Okay, that you should.
Page 50, in fact, page 54. Now, this is a data which is recorded on 30.
Mr.
Well, that is one aspect. And second aspect, my lord, if your lordship kindly looks at the prayer in the writ petition.
Forget the technicality. Show me your right. How
no
were you considered?
My lord?
How were you considered with the maths degree, with the MA degree,
why?
For the post of science? It's a ME school?
ME school.
ME school. Come to 39. Read 39.
39. 39.
39, huh?
My lord. May I just read 39? In case of venture upper primary school, there shall be a minimum of 3 teachers or tutors, at least 1 teacher each for number A,
science and mathematics. Number B, social studies, and C is languages.
So science and mathematics goes together.
Science
You
and
admittedly
mathematics.
don't have the qualification for science.
Well, if your lordship kindly sees, therefore, very preliminary.
Show me
No,
the
I'm trying to
material
show.
on the basis of which the
I'm
whole
trying,
thing
I'm
was.
trying to show. Your lordship will kindly bear with me for a few minutes, my lord. I'll just place everything in the correct perspective. First of all, my lord, why did the petitioner approach this honorable court? What did the petitioner want from this honorable court?
I want nothing, Mr. Borua. I'm least bothered what the principal, what the petitioner is.
Well,
I just want to know how you were provincial.
that is what I'm trying to show, my lord. I'm just trying to show. If your lordship kindly sees the prayer for one moment, I just want to show page number 11, my lord. What does he want? Page number 11, my lord, the first prayer is, page number 11, my lord. First prayer is to provincialize the service of petitioner with immediate effect. Prayer B is to set aside and quash the impugn appointment of respondent number 6 and 7. I was appointed, my lord, way back in 1993. After 30 years, the petitioner has approached this honorable court and is seeking to set aside and quash my appointment. The long and inordinate delay in approaching this honorable court has not even been explained. And the third prayer is to recommend the name for the petitioner for provincialization by DLC and thereafter provincialize her service with immediate effect. Now, my lord, that is why it's very important, my lord. Page 45, if your lordship kindly turns, my lord, page 45. Your lordship will see, my lord, February 9, 1993, I was appointed as an assistant teacher in Pioli Fukon Nagar Adarho ME school, my lord.
Got it.
My lord.
Got it.
And secondly, my lord, even my services were provincialized, page 55. Page 55, your lordship will see 5th January 2021. Name of district Kamrup and name of appointee Renu Bormon, designation is tutor.
You're not tutor science.
No, they teach, my lord, multiple subjects.
No.
A tutor, not only primary.
When the provincialization is of a ME school, 3-9,
My lord.
one is provincialized as tutor science.
My lord,
Others are provincialized as tutors.
tutors. But I was provincialized as a tutor. Now, when was I provincialized, my lord? I was provincialized on 15 February 2021. When did the petitioner approach this honorable court? 1 year back. And this order is not even under the challenge. This order, if your lordship kindly sees page 11 in the of the prayer made in the writ petition, if your lordship kindly turns to page 11 for one moment, my lord, this order is not even under challenge. Page 11 is the prayer. There are 3 prayers I have already read out before your lordship, my lord. This order of
Okay, fine. This is
Yes.
your submission?
No, my lord.
Technicalities, we'll consider.
I'll come, my lord, one by one.
Then you come.
My lord, let me just try to explain myself before your lordship, my lord. Let me place the.
We accept your submission that this matter as a challenge to 93, which is not maintainable. As a challenge to 21, which is not maintainable. Now, this court wants to know, how did that 2021 order came to be passed?
No, that how did that came to be passed will have to be explained by the department.
That's all.
And
fine, Mr.
Mr.
Collector.
Complete. Your lordship, kindly bear me 2 minutes, my lord. 2 minutes. I'll just place everything on record. 2 minutes, my lord. Now, let us see, my lord, how this writ petition was structured. Page number 8. If your lordship. No, just one.
Mr. Borua, first get on record the manner in which you came in. Thereafter, I'll take all this technical, please. Others, I'm not going.
No, this is on merits, my lord. This submission of mine is on merits.
I want to know, in page 15, you have projected yourself as an English teacher.
Which
How
was
could you?
but an error.
You have not said anywhere.
No, but I
You have not even said in your IA.
I have clarified that I primarily teach mathematics.
That will not do.
If your lordship sees.
When you have signed.
My lord, if your lordship kindly sees, my lord, for one moment.
Dice data.
Page 39, paragraph 6. In page 39, paragraph 6, I have clarified. It is categorically denied.
Have you said that this was a wrong thing?
No, I have said.
No, you have not said.
Because ultimately, my lord, this affidavit in opposition has not been rebutted by my learned friend, meaning thereby he agrees. This is an uncontroverted, my lord. Whatever I have stated in my affidavit, he has not even controverted that, meaning thereby, my
Okay,
lord.
Mr. Burma, you want this court to go technical in this?
No,
let's go technical.
No, my lord.
Let's go technical.
I'm just.
My question today is,
I'm just
If
trying to,
15 is there, they also cannot go beyond
my
that.
lord, I'm just trying to express myself.
I'll interfere.
I'm
with
not
everything.
trying to, my lord, I'm just trying to express my points before
I
your lordship.
only want one observation from you, one document to show that, see, this is the basis on which my services as a maths teacher was provincialized. Or rather, you were provincialized as a maths teacher. Show me the SLC minutes or the DLC minutes. That's the end of the matter.
Those would be in the position of the.
Tell that, we'll get that. Yes, Mr. Talukdar. Day after tomorrow, get the DLC minutes and the SLC minutes of the school. Right? Thursday. On the prayer of the parties?
My lord, can it be on Friday, man?
No. Why? Any problem on Thursday?
Thursday.
Have any personal inconvenience? Tell me.
No, I have another part matter on 25th.
Friday.
26th.
On the prayer of Mr. B. Talukdar, Learned Standing Council, Elementary Education Department, list this matter again on 26/4/2024. Mr. Talukdar on the next date shall invariably place before this court the DLC minutes leading to DLC minutes pertaining to the school in question, along with the recommendations made thereon by the state level scrutiny committee, which has led to the provincialization of the services of the applicant. IMMR, applicant.
Response number 6. And my lord, one last small point, which perhaps will have a vital bearing on the facts and circumstances of the instant case. I was just trying to point out paragraph 9 of page 8. Now, in paragraph 9 of page 8, my learned friend had said that the petitioner humbly begs to state that the writ petition of other similarly situated candidates is disposed of by this honorable court, where the facts and circumstances are same with the instant case.
Please bother.
No, my lord.
Mr. Borua, we are here to understand the core issue. Correct. If the core issue you can show that
Correct.
this was a bona fide mistake, but the authorities rectified it, considered me properly as a mathematics teacher, and they provincialized.
I was only on the point of judicial.
They provincialized me. We will dismiss the petition. But the point against you is page 15. You say you are an English teacher, which corresponds to your qualification, right?
Page
15.
Page 15.
Act says science and mathematics. You are an MA.
Yes.
These are the 2 points which
And
we
this
require a clarification.
Same act also says that the section 14 says whenever an issue of this kind is before your lordship, it has to go before the appellate authority. And therefore, 2 different judges of this honorable court had remanded the matter. Just Honorable Justice Mr. M.R. Pathak. In fact, I'll just place this 2 judgments, my lord, just for your lordship's.
Is it binding on me?
No, but it might not be binding.
Is there a
Only
law
for the-
laid down in those judgments?
There is absolutely no law.
Or am I powerless even to understand the manner? Then
That is not what I'm
let me have the understanding first.
That is not what I was
Then
suggesting.
let me have the understanding first.
Absolutely, my lord.
Why should we not go into the root of this?
Absolutely, my lord. There is absolutely no quarrel about it. I was
Mr.
only on-
Talukdar, Friday. And if you don't get it, inform at 10:15. I'll ask the director to bring it by 2. But I want that on Friday. Right?